Good morning, everyone. Welcome back. Thank you for accommodating the various changes yesterday. Let me begin by reminding you of all the various general announcements. If an alarm goes off, we are required to vacate this room. Please take the stairs down, exit, and go to our meeting location. If you've forgotten where that is, I believe there's a sign on the first floor that tells you, so I won't repeat it. This is being webcasted, so please speak into the microphone as you present your comments today and begin by identifying yourself. And take a moment, and if you haven't done so, check and make sure that your cell phones are on silent. I guess I should have introduced myself first. I am Tam Dodek, hearing officer for the BBID ACL, and to my left is Vice Chair Franz Bivey Weber, hearing officer for the WSID draft CDO. Assisting us today are to my right, Counsel Noko Kenzie, to her right, Jane Farwell Jensen. To Ms. Bivey Weber's left is Rich Sakowski, and to his left is Ernie Mona. We also have Michael Buckman over there assisting us. So again, thank you for accommodating the changes, and we look forward to hearing your comments and arguments today with respect to motions for dismissal. Wanted to give you at least a heads up that what we are most interested in hearing today are, because phase one has been focused on the water availability portion of this hearing, we are very interested in hearing on the water availability analysis and the assumptions underlying those analysis. So if you're welcome to make comments during the 45 minutes allotted for each side, but that would be my area of interest. So with that, I will invite those who would like to speak in favor of the motion to present your 45 minutes argument. Another housekeeping item is after we hear all the oral arguments, we will be taking a short break. And that probably will be later on this morning. So as for planning purposes, keep that in mind. With that, Mr. Kelly.
Your microphone's Are we on that? There we go. Good morning. Just so you understand what we're going to do, Ms. Spalletta and I and Ms. Alesi have prepared a PowerPoint that we're going to use that outlines the argument and the citations to evidence.
You're actually welcome to take those seats if you would like. Okay, all right.
And so Ms. Spalletta will speak first, and then Ms. Alesi will pick it up, and then I'll follow Ms. Zolezi. Just so you know, as we're going through, and Ms. Spalletta concludes her portion, it won't be the end. Then there'll be just additional speakers, but we'll all do it within the 45-minute allotted time. Thank you.
Good morning. If we could get the PowerPoint up on the screen, and I first of all wanted to thank the hearing officers for the opportunity to provide this argument today and to outline the evidence and the burden of proof. I agree that it would be very helpful to the process, and frankly, we're very thankful for the opportunity to do that today. Oh, there it is. Okay. I think it's a little hard to see, but hopefully it'll come up. So the motion was a motion for non-suit, and what we thought we would do first is really talk about what that means, what that motion means, and what it means for the hearing officers in the context of what we've seen so far in this case. A motion for non-suit or judgment basically in one party's favor is used after the presentation of a party's case in chief when the evidence is legally insufficient to meet the party's burden of proof. And why is this type of motion even allowed in the law? You know, the big picture here is that the prosecution team has had an opportunity to put on their very best case, all of their evidence supporting the elements that they have to prove. We've had some opportunity to poke at that evidence with cross-examination. They had an opportunity to rehabilitate their case through redirect. And frankly, this is the best their case is ever going to look. At this point, we move on and the other parties get to put on their evidence and then we do rebuttal. But they've already had their opportunity to put their best evidence before you. So if they haven't met their burden of proof on the elements at this point, they're not going to be able to do so as we move forward. So that's the purpose of the motion. We've laid out the standard. You have the ability as a tribunal looking at this motion to weigh the evidence and make inferences and determinations of the credibility of the witnesses, including any experts that were put forth as part of the prosecution team's case. So what exactly is the motion? Mr. O'Loughlin made the motion and it was joined by the Delta agencies as well as WSID and BBID yesterday. So to get to the bottom line of what we could do with this motion, the motion is for judgment or dismissal in favor of BBID in its enforcement action denying the proposed ACL because the prosecution team did not prove water was unavailable during June of 2015. It's the same request for WSID because they did not prove water was unavailable for WSID. What are the elements that they had to prove? The prosecution team asserted the enforcement actions were justified because water was unavailable for WSID starting May 1st and for BBID from June 13th through the 25th. The prosecution team had the burden to establish water was unavailable. They chose to meet their burden with a global water availability analysis, which I'm going to nickname the WAA, from May 1st, 2015 and June 12th. And this was confirmed specifically in Ms. Maroka's written testimony and then again when we cross-examined her, that they were relying on the May 1st and the June 12th determinations. The prosecution team also argued in its opening statement that the enforcement actions were justified to protect the rule of priority. However, you noted, and we of course pointed out, that they chose not to present any evidence in their case in chief of injury to a prior right holder. So what exactly was the burden of proof? The prosecution team argued it was the preponderance of the evidence standard, which basically means they've tipped the scale, that it's more likely than not that water was unavailable. Frankly, it's not a real stringent standard. The other end of the spectrum is criminal cases beyond any reasonable doubt. We argue that the standard in this type of case, when you're dealing with very important public policy issues and very important private rights, is the middle ground standard, which is the clear and convincing evidence standard. So that means that they have to do more than just barely tip the scale. They have to prove that there's a high probability that they are correct. There's a high probability that based on their analysis, water was unavailable. It has also been described by courts as proof so clear as to leave no substantial doubt, sufficiently strong to command the unhesitating assent of every reasonable mind. Respondents contend that regardless of which standard you use, the evidence that the prosecution team presented in its case in chief doesn't meet either standard. So this is just a general overview of the specific grounds for this motion. Now, I will tell you, this is not all the reasons why we think that we would prevail in this case, but we had to limit it due to time, and we're going to focus on these 5 specific grounds and provide you citations to the testimony and the exhibits. The first ground is the prosecution team's admissions that their analysis omitted key elements of water supply. The second ground is their omission that the analysis included excess demand. The third ground is their admission that they did not analyze water availability at the WSID or BBID points of diversion. The fourth ground is the admission that they did not update their analysis for purposes of this enforcement proceeding to include actual demands and supplies which affected water availability and would have been the best available information for enforcement purposes. The fifth ground is that they have presented absolutely no injury to prior rights, and as we will explain later, under California law, there is absolutely no law that supports the concept of enforcement or curtailment of a junior right holder to protect an abstract senior right. You have to prove actual injury. So now let's get into the specifics. the supply omissions in both of the two graphs that the prosecution team relies on. Their Exhibit 47 was the graph they relied on for WSID on May 1st. Their Exhibit 48 was the graph they relied on for BBID on June 12th. First major omission, there was no consideration of the timing for full natural flow to reach the delta. So they selected a methodology which was to look at full natural flow measured at these upstream gauge points and calculated by DWR to reflect natural flows way up at the crest of all of these rim reservoirs. That was their choice. They determined that if water became unavailable at Reading, it became unavailable at Reading the same day it became unavailable at the end of the delta for BBID, and that there's no grounds for that analytical reasoning that has been presented by the prosecution team. Mr. Coates admitted in his testimony that it was actually impossible in the real world for that to be the case. The second ground is the failure to update supply to account for DWR's reconciled monthly unimpaired flows, which were presented by Mr. Nemeth on cross-examination. Those flows were higher than all of the forecasts that were used in the prosecution team's water availability analysis. The third ground is they omitted abandoned releases of stored water. So to the extent there were releases of stored water that were used for a particular purpose or abandoned and made their way into the delta, they were not included at all. The fourth ground is they omitted treatment plant discharges, which are clearly available for appropriators to pick up under their appropriative rights, which was admitted by the prosecution team witnesses. Now, what's of course ironic about that omission is WSID's enforcement action is based in part on a particularly measured treatment plant discharge from the city of Tracy. So on the one hand, they're accusing WSID of unlawfully diverting water. On the other hand, they didn't include that water in their supply analysis. So we have a significant internal inconsistency. The next ground is a complete omission of Sacramento River return flows, even though there were substantial return flows from the Sacramento River that were included in the 1977 version of the water availability analysis. The next ground is that the prosecution team's analysis did not include any water present in the delta channels. They essentially ignored the reality of the delta. They ignored the amount of water sitting in those channels, and it was just completely absent from the analysis. Yet, these two diverters who they are going after in this enforcement action are located in the heart of that delta and divert from those delta channels. Lastly, they computed return flows and subbasin flows that were not depicted in the daily F&F blue supply lines. And we'll talk about that more as we get to the graphs. But the witnesses admitted there were essentially 2,000 acre feet, more or less in given months, of return flow and subbasin flows that they added to their spreadsheet, but they never added them to that solid blue line. So we have a solid blue line that they represented to the world was 2,000 CFS. I said acre feet, it should have been CFS. We have a solid blue line that the prosecution team and staff over the past few years represented to the world reflected supply. But then if you open up the spreadsheet, you have 2,000 CFS of additional supply that they are not adding to that blue line. So we have a serious misrepresentation of supply. Okay, so what were the overstatements of demand that were admitted to by the prosecution team? They admitted that in 47 and 48, they were relying on projected demands, but they didn't go back for the purposes of enforcement proceedings and do a specific calculation based on actual diversions in 2015 that were reported by diverters, which reduced demand by approximately 2,000 CFS in June alone. They included demands of agencies such as the North Delta Water Agency. They admitted that all of the demands from that entity were included, even though there is a contract with DWR to provide stored water to meet the demands of that agency. They included demands on watersheds that could not be met from supply in that watershed. So for example, on the Tuolumne River, they included all of the demands in the Tuolumne system, even though the full natural flows for the Tuolumne were significantly below those demands, meaning that it was physically impossible for all those demands to have been met, and that overstatement of demand was then pulling water out of all the other watersheds in the model, which created a physically impossible and completely misleading picture of supply and demand, particularly in the Delta. Next, DWR randomly assigned all joint pre-1914 riparian claimants to a riparian senior demand, and that, of course, skewed the view of which demands had priority and where they fell in the demand analysis. Finally, they did not include corrections to the joint board's demand of 740 CFS. Mr. Yeasel explained that this correction was necessary in his spreadsheets and indicated that it was insignificant, but then of course when we brought up the graphs and cross-examined him, it did make a significant difference, which he was forced to admit. What were the, yes?
Just for the record, on the previous slide, when you say DWR, you don't mean Department of Water Resources. You mean the prosecution team.
Oh, I'm sorry, yes. It should say Division of Water Rights. I'm sorry. It was late last night when we were preparing this, so there may be a few of those in here, and I'm very sorry if there are. Okay, internal inconsistencies. There are a lot of internal inconsistencies in what we saw from the prosecution team's case. And these internal inconsistencies in and of themselves really cast doubt on the credibility of the methodology. It's not that the data itself may have been flawed in all cases, but it's how they use the data to make these water availability decisions. So again, the May 1st water availability analysis that was used for WSID omits any of this return flow for the Delta or the San Joaquin River that they ended up adding in to the June 12th analysis. So it may have been that they were refining the way they looked at supply as they went in 2015, but here we are in 2016 for enforcement purposes, and they knew about that refinement and they didn't go back and fix it for the purposes of saying when water was unavailable for enforcement purposes, and that's really problematic. The second internal inconsistency is, again, the 740 CFS of excess demand that was removed a few days after the June 12th graph. Again, they didn't go back and fix it for the purposes of the enforcement proceeding, even though they know it was an error. The next major internal inconsistency is supply is depicted on a daily average time step, and demand is depicted as a monthly time step. And this occurs on all the graphs. And it creates a very misleading picture because they were actually looking at both pieces of data on a monthly time step, but then graphing them on a different time step. So the data becomes very hard to understand and misleading when you look at it on the graph. The next one is that the F&F forecasts, which were their dashed lines that they used on the May 1st and June 12th graphs, again, they included 2,000 plus CFS of additional supplies, but they never add those to those daily F&F lines. And that gets more egregious as we go through the year and we look at the after the fact graphs that they produced in August or in October, where they say, if you look at what happened after the fact, we were right back then. Well, here you have these blue lines that are still missing 2,000 CFS of supply. And they never take the time to add that back in and shift that whole supply line up to reflect what even they admit was additional supply. Probably one of the most interesting admissions that came out in Cross was that water availability staff treated demand as hypothetical prior to May 1st, but then called it the best available data on demand for purposes of curtailment. So Mr. Kelly asked Ms. Maroka, if your supply line's way down here and your demand line's way up here on March 1st, why weren't you doing anything about it? And after a discussion, she says, well, if that demand reflects that they were diverting, as if it was hypothetical. But then a couple months later, it was definitely the demand and it was sufficient to do curtailment. And then a year later, it was absolutely the demand and it was sufficient for enforcement. So we have a real inconsistency about how staff even viewed their own depictions of supply and demand in this chart. Finally, the after-the-fact graphs show that the actual 2015 diversions far exceed the prosecution team's depicted supply, which is physically impossible, and they were not able to explain. So at this point, Mr. Buckman, could we please put up what's Water Right Exhibit 58? So I questioned Ms. Maroka about this exhibit, which was one of the after-the-fact analyses the State Board did for the San Joaquin River, and I said, we've got this green line that represents your actual reported 2015 diversions, and this blue line that represents what you say is the actual demand, and we've got, I believe it was 3,500 CFS difference, which was physically impossible. The only conclusion you can reach from this is that demand is overstated, supply is understated, or the analytical method does not capture what is actually going on in the stream system. And we would present to you that all three of those things are happening, which is why these graphs look so strange. Okay, if we go back to the PowerPoint. Okay, so now let's apply all of those things to the graph. So here we are with the after-the-fact graph for the Sacramento Basin, and we have that same odd, impossible reality sitting in front of us. We've got an actual demand green line that's way above, at the end of June and July, the actual supply as depicted by prosecution team, again reflecting physical impossibility. We also have, as we said, a blue line that staff admitted was understated, a blue supply line that does not include 2,000 CFS of return flows and sub-basin flows. We have, just looking at the graph, a recognition that at least in the month of May and the beginning of June, even that understated supply line, blue, is above the green demand line. So there was more water in the system, according to the prosecution team's own evidence, necessary to meet senior demands. And yet Westside has a 1916 license, which would be just right above that green line. And there's no explanation for this. Mr. Coates actually said something completely contradictory in his direct testimony. He said that this graph proved they were absolutely right in curtailing Westside, yet their own analysis, without making any of the corrections we've talked about, shows the blue line above the green line. So, and again, even here with this green line, we have demand included that was met with other sources of water. So again, that graph confirms that water was available to Westside in May, even without correcting all the other errors. Now, let's go back and see what the prosecution team used for its case to say that water was not available for Westside. They used the old graph from April 29th, which definitely paints a different picture of the world. But this is not reality. And all the problems with this graph are brought home by the one that they did after the fact. What about the admitted errors that misrepresent water available for BBID? Mr. Yazel, the person who generated the graphs and manned the spreadsheet, admitted on cross-examination that after only 2 corrections of the many we've talked about, the spreadsheet for June acknowledged the supply line would exceed the demand line. I'd point you back to the burden of proof and how you review the evidence. With all of the other identified errors, the hearing officers cannot conclude it was more likely than not that water was unavailable, let alone that it is so clear as to leave no substantial doubt. The evidence in front of you does not allow you to meet those standards. This is the specific quote from Mr. Yazel where he made that admission. It's page 219, lines 8 through 22. This is the graph, of course, that was relied on for BBID's unavailability determination, and this is the graph that Mr. Yazel's admission relates to. Again, we've tried to tie in here with errors all of the things that I listed before and why you've got an orange demand block that's overstated, a blue supply line that's understated, and a lot of other hidden errors in the data. Finally, the prosecution team put forth its panel of witnesses as experts, and Ms. Maroka, as the proclaimed enforcement team lead, offered an expert opinion that this analysis was not only appropriate, but it used the best available information. She then admitted, though, during her testimony that she couldn't explain the specific supplies or demands used in each analysis. She couldn't even tell you which spreadsheet they were. She didn't review Mr. Yazel's work. So she frankly doesn't have the ability to testify as an expert for the opinion that she offered. I also want to point out something we pointed out in our opening statement, which is Evidence Code Section 412. It tells you how to view weaker evidence when it was within the power of the presenting party to put forth stronger and more satisfactory evidence. Mr. John O'Hagan made the decisions about this methodology, but he wasn't here to tell you why. And that is something you should take into account. And with that, I'm going to turn this over to Ms. Salesi.
Thank you. I know you were interested in the water availability analysis, and I hope Jennifer gave you a good overview of that. But it's important to note that there were two prongs that the prosecution team had to prove. First, they had to prove that there was no water available. And then even if they could meet that burden, which we don't believe they have to prove that someone was injured because these two districts took water when there was no water available. And the fact is that not only did they not meet that burden, they didn't introduce any evidence of that fact whatsoever. Their theory is based upon a presumption, and they presume that if their availability analysis proved no water was available for a certain priority of water right, not an individual right, but a category or a priority of right, then if someone in that priority category diverted, they presumed that someone would be injured. And this kind of approach, it was allowed in California 100 years ago. A senior water right holder used to be able to say, I need all the water in that stream, so you need to stop those juniors upstream from diverting so I can have my pool of water. But 90 years ago, that approach was outlawed in California. When the Herminghaus case was decided 90 years ago and followed up by Article 10, Section 2 of the California Constitution, it abolished that common law doctrine and said, we don't work that way in California. Water is too precious. If there is water available in the stream that is not needed by that senior downstream, then the junior diverter can use it. That is how we operate in California, and that's why it's so important to look at an individual diversion, because that senior downstream may have a demand on paper of 50 CFS, but he may have used that yesterday and not today, or he may be using 10 CFS today. And we don't stop that junior upstream from diverting just because that senior might use 50 CFS tomorrow. That's not the way the system works. So we've given you the citations of the cases that clearly show that is the case in California today. The Supreme Court just recently affirmed that in several cases, stating that we simply don't have enough water in California, and we have to look at how much water is in the stream and who actually needs that water. And a result from that is this approach that the prosecution team took to curtail based upon theoretical injury to prior rights is not allowed. As far back as decades ago, the courts did not take theoretical or technical infringement of senior rights as a basis for curtailment. There has to be proof of injury. We've required that in California since the 1930s. So we've seen the standard of what they have to show, which is actual injury to a senior diverter instead of this theoretical. And what we've seen from the case in chief is that not only do they not have evidence of any injury to an individual water user, they didn't look for that evidence. They didn't think it was needed. Now, the prosecution team didn't even consider whether or not WSID and BBID were diverting project water. So that's not an issue here. They admitted they didn't do an analysis of the availability at either specific point of diversion. Mr. Coates admitted that they didn't evaluate water availability at the points of diversion. Rather, they did a comparison, not a water availability determination, for whatever that means. They admitted that they determined availability based solely on the water supply analysis on a watershed-wide basis. They admitted they didn't investigate which parties would have been impacted, that they didn't investigate any individuals for injury, and admitted that they had no evidence that the failure of the districts to stop diverting actually harmed another more senior water right. Instead, Ms. Maroka testified that they made the presumption. She testified in 2 different locations in the record that they made a presumption that there would be injury. So we clearly think that the prosecution team had 2 burdens to meet, and it didn't meet either of those. And the districts aren't disputing the importance of the rule of priority during times of shortage. To the contrary, we believe the rule of priority is essential, particularly when the supply of water is insufficient. And meeting the prosecution's burden is also essential to protect the priority of rights. That's what's important, is that your priority is determined, and then it is determined that you do not have sufficient water under that priority. That's what they failed to do here. And we think in order for this case to provide, as the prosecution team has testified it wants, a good test case to set precedent for the future of the Delta, something more is required. The prosecution team didn't meet the burden to impose monetary fines in the millions of dollars against BBID, or to ask for a CDO against WSID, and we would request that you look at this and consider it carefully. I'll turn the remaining time over to Mr. Kelly.
And just to follow up on Ms. Zalesi, the references to the evidence that supports what she was saying is included in the PowerPoint, and we'd be happy to make that available to the extent that you'd like to reference that when you consider the motions. I want to talk a little bit about the water availability analysis and the rule of priority, because we heard how important that is to protect the rule of priority. And one of the things that I would like for you all to consider as you deliberate these motions is whether or not that applies only to the seniors that weren't curtailed, or whether that also applies to the water right holders that were curtailed, or that theoretically had no availability pursuant to the analysis that you heard on Monday. Because just like a senior downstream of BBID who might be injured has the right to have their senior water right protected, BBID and WSID, the folks in the back of this room, have the right to have their water supply protected as well. And that means if there's water available under their priority, they need to be able to take it. That we can't be curtailing people and cutting people off based on theoretical lack of supply if there's really water there. That's not how the system works. And so as an example of this, I'm going to just talk about the difference between riparian water rights and appropriative water rights. Riparian water rights don't exist in the abstract. Riparian water rights attached to land when they transfer from government ownership into private ownership. That's generally when a patent's issued. So a patent is issued, passes to private ownership, and that's the date that riparian water rights vest. Now, interestingly enough, in California, there was occasion, and there are many, many circumstances where some people establish appropriative water rights on water courses before land passes from the government to private owners, before those riparian water rights vest. In those circumstances, appropriators are senior to riparians. The California case law is absolutely clear that upon passing to private ownership, lands contiguous to streams are vested with riparian rights in the streams, subject to appropriative rights already vested. That is black letter law. It's in Hutchins. It's in many California cases. And so when property passes from the government and riparian rights vest, if somebody had already established an appropriative water right on that water course, that appropriative water right holder has a better right than the riparian. The prosecution team's demand analysis inappropriately assumed all riparian rights were senior to all appropriative rights. We could go into testimony to look at that, but we don't have to. Pick any of the demand graphs that they used for the curtailments, any of them. All the riparian demand is the most senior on the bottom, and then it has pre-14 over it, and then post-14. There's no evidence at all that all of those riparian water rights are senior to all of the appropriative water rights. There was absolutely no consideration of whether any of those riparian water right holders had to get behind some of those appropriators. And so it really didn't protect the priority system. It actually turned it on its head, because it simply assumed inappropriately that everybody who had a riparian right was entitled to take water before anybody with an appropriative water right. Another example, I will tell you, there's this one piece of evidence in the record, but this happened more than just this one time. But we use this as an example, that the Division of Water Rights, and Tom Howard told the Sacramento Municipal Utilities District with a post-1914 water right, when curtailments issued, that they could go ahead and they could divert water all summer long into storage for hydropower because it was a non-consumptive use, because that water would eventually be returned to the stream. Well, that doesn't matter that it's going to be returned to the stream in July or August to Byron Bethany Irrigation District or to WSID. That real water was taken out of the system, and people downstream were deprived of that real water. Ms. Maroka testified that, well, the Bureau of Reclamation releases water to make up for full natural flow. There's absolutely no evidence that there were any project operations that replaced that water for downstream water right holders, and that they were actually entitled to take that. In fact, you've got a lot of folks in this room that are arguing nobody's entitled to take any of that stored project water. But you know that the Sacramento Municipal Utilities District diverted water all summer long under a post-1914 right in light of curtailments. That doesn't protect the priority system. It absolutely doesn't. It allows somebody to jump way ahead of other senior water rights. That's not protecting it. As Ms. Spalletta also explained, when we look at the graph, and which number? 47, WR 47?
But it's slide 13.
Slide 13. Let me back up. There. When you look at this graph, if you look at March and April and where that supply line is, Ms. Maroka testified that there was insufficient water for everybody above that blue line, but all those people diverted. We have Mr. Yazell put the 1950 priority line on there. That was 2/3 of the way up that graph. There was insufficient supply for all those people, but they all diverted water. All spring long they diverted water. If the full natural flow supply line you see on here and that demand is used to protect the priority system, then the prosecution team didn't do that. And they can't explain to you how it protects the priority system when you've got 80% of people diverting in excess of the supply, according to this graph, which is what they used, which is what they're trying to use to prove their case. It doesn't protect the priority system. In addition to the graphs that show the riparian demand being senior, Mr. Yazell testified to that on page 246 of the transcript, starting around line 5. So in conclusion, The case in chief establishes that the prosecution team didn't consider all the sources of available supply into the system, and you were provided no explanation through those witnesses as to why the supply that was in the Delta was excluded. Not a word, no testimony at all as to why that was excluded. They hadn't considered basic Delta hydrology. They included excess estimates of demand, and you heard some examples of that, and they were significant. They didn't consider water availability specific to WSID or BBID, and that's important. That's very important, because what we have here is we have this board and its prosecution team attempting to impose, again, look at the ACL, a fine in excess of $5 million on the folks in this room. And don't they deserve more than being prosecuted based on a watershed-wide availability that has all these errors without looking at all at the actual water available to them at their point of diversion? They deserve that. That's how the water rights system works. They deserve that. The analysis might be useful for some general planning tool or in some larger context, but when it comes to trying to impose those kinds of penalties on people, it's not good enough. You should demand more. They demand more. So instead of conducting that kind of analysis, the prosecution team and their witnesses simply assumed that demand outstripped supply. They presumed without any evidence that any diversions would injure more senior water right holders. There's no evidence that anybody was injured. There's none. As Ms. Alesi said, theoretical injuries don't do it. They simply don't do it. They failed to present evidence sufficient to support a finding that it was more likely than not that water was unavailable for WSID and for BBID, let alone that it was a high probability that there was water unavailable for them. And that's their burden of proof. Again, if this proceeding isn't about the notice, which you've all said it's not about the notice. The notice was informational only and gave people an idea of what was generally happening in the watershed and what the hydrologics, what the system looked like. And if that's truly all it did, and if the prosecution of these two actions is truly about the actual water availability for these two districts, for BBID, for 12 or 13 days in June, if that's what this is really about, you've been provided no evidence, no credible evidence, no competent evidence that there was water unavailable for BBID during those 2 weeks. There's no evidence of the water that was even present anywhere near BBID. So I'm asking you, and I'm pleading with you on behalf of these folks, to consider the context within which these enforcement actions were brought, and to think very hard about whether or not the evidence that you heard on Monday and the evidence that you didn't hear on Monday is sufficient to prove the allegations that are contained in the administrative civil liability complaint and the draft cease and desist order. I will tell you that there are a lot of people that watched that on Monday and were frustrated. But we finally got to shine a light on it Monday. And it's the first time in 8 months these people have been able to understand the analysis that went into the ACL that BBID received. And they were shocked. And you should be shocked. And from here, there should be a commitment to refine the analysis, to get better data, and to make it more useful in the future. And I think everybody in this room would commit to doing that. But the analysis isn't sufficient to punish these people. It's simply not. And we'd like to reserve the remaining 4 minutes if we can, to the extent we need it, for addition to the 5 for the rebuttal. Thank you.
Any questions for respondents? All right. Mr. Cheriainen and all those who wish to speak in opposition to the motion, you now have your 45 minutes.
Thank you. Before I begin, I have a point of order question. I heard the speakers just now offer that PowerPoint slide to the board. If the board is going to be accepting it, I'd like to get a copy too, if the parties can all get a copy. So it sounds like that'll be accepted. Then I would also like to, at the conclusion of my presentation, submit the written version of my presentation, if that's okay. Thank you.
Granted, Mr. Terriainen.
Thank you. Good morning, hearing team, hearing officers. The prosecution team requests that the hearing officers deny the motion for a non-suit. As I will discuss, this motion has no place in an administrative proceeding before the board. And this motion has no place in this proceeding because on February 18th, the hearing officers specifically ruled that they would not entertain such a motion during this proceeding. But even if you entertain this motion, the law requires that you deny it, because the relevant civil procedure standards that might inform this process are deferential to the prosecution team. The hearing officers must disregard all conflicting evidence and give the prosecution team's evidence every legitimate inference. And the hearing officers must allow the prosecution team to present curative evidence on the prosecution team's request and on offer of proof. Accordingly, the prosecution team hereby requests that, should you find defects in its case-in-chief witness testimony, that you give it an opportunity to correct any such defects. As I will discuss, the prosecution team makes this request with a specific offer of proof that redirect of Mr. Yazell and of Mr. Coates, if necessary, will demonstrate that the supply inputs and the demand adjustments, with or without the cross-examination testimony that was put in, support a finding that there was no water available to serve BBID during June 13th through June 24th, 2015, and that there was no water to serve WSID after May 1st, 2015. The prosecution team requested redirect examination during hearing that would have cured any alleged defects, and that request was denied. The hearing officers cannot now grant this motion for non-suit without first allowing the prosecution team the opportunity to conduct the requested directed examination. Moreover, all other anticipated defects raised by the Delta parties are addressed in the prosecution team's rebuttal. Accordingly, the prosecution team hereby additionally offers the entire rebuttal testimony as an offer of proof regarding any such defects. The motion, at least as raised by Mr. O'Loughlin yesterday, is based on a number of fundamental mischaracterizations, some of law and some of fact. The moving parties misstate the law by imputing a harm standard into Water Code Section 1052's definition of trespass, when there is no such standard in the statute. Harm is one of the many factors that the board may consider under Section 1055.3 when setting a liability amount, but it is not required in order to find Byron Bethany or Westside liable for trespass or threatened unauthorized diversion under Section 1052. The liability amount is a Phase 2 issue in the BBID proceedings. We're not there yet. The moving parties misstate the facts by mischaracterizing the key issues in this phase and by focusing on evidence relating to days outside of the alleged violation days. Ms. Spalletta knows what the violation days are, yet in what can be described as a lack of candor, particularly after her opening statement, she focused her cross-examination entirely on full natural flow available on June 7th. Which is really just another attack on the June 12th notice. The prosecution team pointed this out in its request for redirect examination of Mr. Yazell, and counsel made an offer of proof that redirect would focus on the unavailability for the correct days, June 13th through June 24th, but it was denied that opportunity. The moving parties, and particularly Mr. O'Loughlin, also mischaracterized the prosecution team's opening statement presentation. By necessity, the opening statement, discuss the evidence that would be submitted during the case-in-chief and rebuttal in each phase of this proceeding. When I spoke of the evidence supporting the prosecution team's recommendations in Phase 1, I was referring to all of that evidence, including the prosecution team's, and perhaps evidence that would be submitted by other parties. Moreover, Mr. O'Loughlin himself displayed an extreme lack of candor when he suggested to Kathy Maroka that I indicated that the prosecution team would demonstrate injury or harm to any party. I look back over the transcript of my opening statement, and I never said such a thing. In fact, according to the rough transcript, only Mr. O'Loughlin and Mrs. Alesi ever mentioned the words injury or harm on the first day of hearing. except for an occasion where the hearing officer said harm while clarifying a cross-exam question. But it does not even matter what I said in my opening statement. It only matters what the law is. Section 1052 does not require the prosecution team to demonstrate harm in order to prove a trespass. There's a long list of board authority on this point. To that end, I stated in the opening statement that the Phase 1 evidence would show that there was no water available for BBID's diversions from June 13th through June 24th, 2015, and for Westside's actual or threatened diversions after May 1st. I will describe that evidence later in this presentation. In thinking about this argument, a phrase echoed in my mind that we heard Monday. That's why are we here? These proceedings are an administrative enforcement proceeding brought under Water Code Section 1052 and Section 1831. According to the most recent notice of revised schedule dated January 8th, the key issues for this phase are, and I want to state them for the record, was the water diverted by BBID from June 13th through June 25th, 2015, if any, unavailable under its claimed pre-1914 appropriative right and all other claims of right by BBID. 2, was the water diverted by Westside WSID after May 1st, 2015, if any, unavailable under License 1381 and all other claims of right by WSID. A non-suit has no place in a State Water Board adjudicative hearing. Non-suits and dismissals are governed by Title 8 of the Code of Civil Procedure, which applies to actions and special proceedings. An action is an ordinary proceeding in a court of justice. That's Section 22 of the Code of Civil Procedure. A special proceeding is every other proceeding of a civil nature under the Code of Civil Procedure. That's Section 23. An administrative proceeding, by definition, is neither a civil action nor a special proceeding of a civil nature. The citation for that is City of Oakland v. Public Employees Retirement System, 95 Calap 4th, 29 at page 48. Non-suits and dismissals do not apply in administrative proceedings, but that's what this is. State board regulations incorporate certain elements of the Code of Civil Procedure for discovery, the Evidence Code, Administrative Procedures Act, yet they differ in important respects from the Code of Civil Procedure. For the State Water Board, an adjudicative proceeding means an evidentiary hearing for determination of facts pursuant to which the State Board or a regional board formulates and issues a decision. That's 23 CCR Section 648 Subdivision A. Section 648 Subdivision B provides that except otherwise provided, all adjudicative proceedings before the board shall be governed by regulations in Title 23, Chapter 1.5 of the Code of Regulations, Chapter 4.5 of the APA, Sections 801 through 805 of the Evidence Code, and Section 11513 of the Government Code. That's it. The board's regulations and applicable sections of the Government Code governing the board's adjudicative proceedings do not provide for dismissals, non-suits, or similar motions. Since there is no procedure for dismissals and non-suits, granting a motion to dismiss or for non-suit would be arbitrary and without basis. Entertaining a motion to dismiss or for non-suit is similarly a tremendous waste of time in this proceeding. We've delayed these proceedings by more than one full day for this motion so far. The hearing officers even issued a ruling on procedural matters on February 18th, stating on page 7 that we will not allow the parties to submit a motion for judgment as a matter of law during the hearing. Any such motion may be made in writing, either in the party's written opening statement or after the close of hearing in the party's closing brief. There was an opportunity to make these kinds of statements. Again, why are we here? Granting a motion for non-suit would violate the hearing procedures that the hearing officers themselves issued for this hearing. To change that ruling would be arbitrary now and demonstrate that the hearing officers may be proceeding in the absence of any procedures. If there's no basis to even entertain this motion, again, the prosecution asks, why are we here? Well, since we are here, another phrase was echoing through my mind. If we're going to do this, let's do it right. There are no guiding standards for non-suit motions in these proceedings. The Code of Civil Procedure and interpreting cases are instructive. Now, the moving parties cited Section 631.8 of the Code of Civil Procedure. That's not the standard that informs this stage of the proceeding. At this stage of the proceeding, the prosecution team has not submitted rebuttal. There have been two other phases that have not been even had any evidence entered in at all. The proper standard at this stage, before rebuttal, is Code of Civil Procedure Section 581C. Section 581C governs non-suits. in covered proceedings and provides that only after and not before the plaintiff has completed his or her opening statement or after presentation of his or her evidence, the defendant, without waiving his or her right to offer evidence in the motion, is not granted, may move for a judgment of non-suit. Now, the court's power to grant a non-suit or to direct a verdict are analogous to the power to grant a motion for judgment notwithstanding the verdict. Cite for that, Beavers v. Allstate Insurance Company, 225 Calab 3rd, 310, at page 327. While made at different times, these motions are analytically the same and governed by the same rules. Cite Fountain Valley Chateau Blanc Homeowners Association v. Department of Veterans Affairs, 67 Calap 4th, 743 at 750. The function of these motions is to prevent the moving defendant from the necessity of undergoing any further exposure to legal liability when there is insufficient evidence for an adverse verdict. That being said, long-settled case law provides that granting a motion for non-suit is warranted, and this is a quote, when and only when disregarding conflicting evidence and giving the plaintiff's evidence all the value to which it is legally entitled, and indulging in every legitimate inference which may be drawn from that evidence, the result is a determination that there is no evidence of sufficient substantiality to support a verdict in favor of the plaintiff. Citation among many is Keller v. Pacific Turf Club, 192 Calap 2nd, 189 at 190. Another quote, in determining whether plaintiff's evidence is sufficient, the court may not weigh the evidence or consider the credibility of witnesses. Instead, the evidence most favorable to the plaintiff must be accepted as true and conflicting evidence must be disregarded. The court must give to the plaintiff's evidence all value to which it is legally entitled, indulging every legitimate inference which may be drawn from the evidence in the plaintiff's favor. Cite is Carson v. Facilities Development Co., 36 Cal 3rd, 830 at 838 through 39. So, in considering a motion for a non-suit, the court and this tribunal must accept as proved all facts that counsel says in an opening statement and must indulge all favorable inferences reasonably arising from those facts. Citation Smith v. Roach, 53 Calap 3rd, 893 at 897. A court may properly enter a non-suit only if the evidence, viewed most favorably to the plaintiff, with all conflicts resolved and all legitimate inferences drawn in the plaintiff's favor, does not support a verdict for the plaintiffs. Ayer v. Boyle, 37 Calap 3rd, 822. Again, all conflicts must be resolved in favor of the plaintiff. And if different conclusions or inferences can reasonably be drawn from the evidence, the court still must adopt those conclusions and inferences which are favorable to the plaintiff. Libby v. Conway, 192 Calap 2nd, 865 at 868.
Sorry, Aiden.
Yeah.
Are the rest of your arguments legal arguments in nature?
No, there's plenty of facts.
Okay. Why don't you get to the facts? Since we will be receiving your written statement for the record, we will examine those legal arguments at that time.
I have one more quote that is highly relevant, and I would like to state it in the open proceeding for the record, and then I'll go on to the rest of my argument. There are facts, but again, part of this motion is based on a legal interpretation of 1052, so a significant portion of my argument will be, not a significant portion, but there will be a portion of the rest of my argument dedicated to interpreting 1052, which was a big part of the opening argument too. So regarding the standard, the evidence most favorable to the plaintiff must be accepted as true. Conflicting evidence must be disregarded, including evidence brought out on cross-examination of the plaintiff's own witnesses. Miller v. Los Angeles County Flood Control District, 8 Cal 3rd, 689 at page 700. So if we're going to do this right, the hearing officers must disregard any conflicting evidence proffered during the cross and must give every indulgence to the prosecution team's case-in-chief evidence. So, as I stated earlier, the plaintiffs do have the right upon request to reopen and remedy the defects in this case, and I think this is an important factual issue, and I'm going to make an offer of proof regarding facts now. The prosecution team hereby renews its request for redirect examination of Mr. Yazell and requests redirect examination of Brian Coates and Kathy Maroka in order to correct any alleged defects and to introduce, as allowed, further evidence demonstrating that there was not water available for these defendants' rights during the relevant violations period. This request I make with the specific offer of proof that redirect of Mr. Yazell will demonstrate that the 740 CFS of demand reduction in Ms. Spoletta's cross-examination hypothetical is not based in any fact presented by the evidence. More importantly, the prosecution team will show that the addition of 2,252 CFS to the daily full natural flow calculated data, whether combined with Ms. Spoletta's proffered 740 CFS demand reduction, or whether combined with the actual demand reduction requested by outside commenters as described by Mr. Yazell in his testimony, will not provide supply to BBID's pre-1914 priority during June 13th through June 24th, and will not provide supply to WSID after May 1st. The same evidence will demonstrate that these adjustments, if made to the June 7th full natural flow calculation that was the subject of Ms. Spoletta's cross-examination hypothetical, and on which Mr. O'Loughlin based this motion, would not have changed the analysis or the determinations regarding unavailability after June 12th. The prosecution makes another offer of proof that its rebuttal testimony also demonstrates that using the actual 2015 information order demand data provided by the respondents to that order will not move the needle sufficiently to show that BBID or WSID had water available for their actual or threatened diversions. Again, the hearing officers can't grant this motion based on any defects alleged by the cross-examining parties because those defects are all alleged in the rebuttal that the prosecution team has not yet presented. But I do, as an offer of proof, offer the entire rebuttal testimony regarding any such defects. I have a couple of points regarding some of the fact issues that were raised in the opening. The first regarding the omission of timing of full natural flow. That's a rebuttal issue. The prosecution team witnesses deal with that on rebuttal, particularly Mr. Grober. Regarding the allegations of excess demand, that's dealt with on rebuttal by Mr. Yazell. It hasn't been presented yet, Mr. Yazell and Mr. Coates. Regarding the availability of water at the points of diversion for WSID and BBID, again, that is rebuttal testimony that hasn't been presented yet. The update with the 2015 information order I just described, again, that's a rebuttal and it does not move the needle. Finally, and I'll move now to the no injury allegation. The moving parties' primary, and we saw it repeated several times, mischaracterization of the standards governing these proceedings is the claim that the prosecution team must demonstrate harm to some specific senior water right holder in order to show a trespass made by BBID or a threatened trespass or unauthorized diversion by WSID. They claim that trespass under Water Code Section 1052 does not occur in the abstract. They're right, only to the extent that Section 1052 requires an unauthorized diversion in order for there to be a trespass. One thing you did not see in that opening slideshow was what 1052 says, the text. 1052 Section A says, the diversion or use of water subject to this division other than as authorized in this division is a trespass. The section does not talk about harm. It doesn't say as long as somebody downstream is harmed and you can show that. It says when you divert without authorization, that's a trespass. It's a trespass against the state. As directed in the BBID matter, the prosecution team has already briefed the applicability of this section to even pre-14 rights. Those are the Millview and Young cases. I won't go through them again. But I will note that the San Joaquin Tributaries Authority alleges at page 6 of its pre-hearing brief of legal issues that the board cannot step into the shoes of a water right holder and represent their interests against other pre-14 water right holders. That is an iteration of this trespass argument. I will note that the authority in that brief only cites one page of Young v. State Water Board as support, and the Young case does not support that proposition. To the contrary, the very page of the opinion cited by the authority in that brief, the court agrees with the Water Board that, quote, put simply, the claim that a diversion is authorized under riparian or pre-14 right is no different from any other argument that there has been no unauthorized diversion. The argument does not deprive the State Water Board of the authority to determine whether an unauthorized diversion has in fact occurred or is threatened. Now, People v. Shirkow, which is 26 Cal 3rd at 301, actually stands for the proposition that the unauthorized diversion or use of water is a trespass against the state. No specific showing of harm against a specific party is required. Now, we looked. There aren't any case law that says 1052 requires harm to anyone else in order to show a trespass. And we went back and looked at the last 10 years of state board orders following hearings on administrative civil liability complaints, all of them have consistently held that harm or injury to specific parties is not a factor in determining whether a trespass was occurred. Instead, harm comes into play in discussing, among many factors, in setting the amount of a penalty. These cases are the Lake Arrowhead Community Services District case, WR 2006-1. Here, the board found that the unauthorized diversion may have resulted in injury to water users downstream in the Mojave watershed, although there was no evidence of specific injury in that case. The board applied harm only, that finding regarding harm, only in calculating the penalty. Two cases from 2008, the North San Joaquin Water Conservation District, WR 2008-17, and the Vineyard Club, 2008-15, both held that permit term violations are unauthorized diversions, and thus trespasses, even though no evidence of specific injury to any party or anything was offered or raised in that case. Last year, 2015, the board issued an order against Robert Mann, WR 2015-25. In that case, the prosecution team specifically alleged and argued that unauthorized diversion under 1052 is a trespass against the state, and the board agreed. The board only looked to harm for the penalty calculation, and even then, this is a really important point, noted that there was no evidence of actual harm in that case to any senior water right holder. Instead, the board itself took official notice of the existence of senior rights in the watershed. And here's how they did it. They noted that there were records of senior rights in the watershed publicly available on the Electronic Water Rights Information Management System, on ERIMS. None of these cases addressed injury or harm to a specific party when determining liability under 1052. The only relevant section addressing harm for this matter is section 1055.3, which states, in determining the amount of civil liability, the board shall take into consideration all relevant circumstances, including but not limited to the extent of harm caused by the violation, the nature and persistence of the violation, the length over which the violation occurs, and the corrective action, if any, taken by the violators. There are other factors that can play. But 1055.3 is a BBID Phase 2 issue. We're not even there yet. The prosecution team tried to present a minimal showing regarding BBID's actual diversions and Westside's actual and threatened diversions, but we were instructed that that was unnecessary. Now, protecting the priority system is not just something in the abstract. Protecting the priority system protects all of the water right holders senior to BBID and Westside, and they exist in the watershed, in the Delta. It protects the state's water supply, and it preserves orderly administration of water rights. Now, even if a motion for a non-suit were applicable to this proceeding, and it is not, the relevant standard holds that such a motion, the board must accept as proved all of the facts the prosecution team offered or expects to prove and indulge all favorable inferences reasonably arising from those facts. The prosecution team should be allowed to redirect as requested in order to cure any alleged defects prior to a ruling if the board is inclined to rule. All of the evidence offered by the prosecution team, both in its written testimony, direct and rebuttal testimony, demonstrates that under any manipulation of the data as suggested by BBID and Westside, and that's all those charts were, where they added things to what the exhibits were that the prosecution team presented, just manipulations of the data that they suggested, there was still not enough water to satisfy Byron Bethany and Westside's rights during the June time period, and for Westside during the entire unavailability period, which began in May and extended until November. The written evidence presented demonstrates the following. I want to make sure to make that really clear. I did this on Monday. The written evidence is the testimony. The written testimony and the exhibits cited, that's the testimony. That's the evidence in this case. We're guided by the hearing instructions to just provide summaries here. The written testimony is what guides this proceeding. Mr. Coates, in his written testimony, which is WR9, makes the following statements. For the supply curve in each watershed, which has been a big Point of contention, staff relies on DWR's full natural flow Bulletin 120 forecasts. These are forecasts that predict full natural flow of water at stations that provide the largest impacts to a river's supply. Pardon me, I'm trying to quote the testimony here. I may paraphrase slightly, but it's generally true to the testimony. This is to be contrasted with DWR's daily full natural flow data, which are not forecasts of future availability, but calculations performed by DWR on the amount of available water on days past using stream gauge values, known upstream diversions and reservoir data such as changes in storage and posted evaporation numbers. This is important. Staff only use the daily data to determine which full natural flow monthly forecast is tracking closest to reality for the purpose of predicting future full natural flows, or when the daily full natural flows are higher than the monthly forecast, since a higher supply is of more benefit to diverters. What that means is that instead of the daily full natural flow calculation being the support for the June 12th notice or the May 1st notice, which again isn't relevant to the question of whether water was availability from June 13th to June 24th or from May 1st through November, they use the full natural flow to determine the notice, not the daily trend. That's just a check. Mr. Coates testifies that for
Mr.
the...
Chair,
Yeah.
stop. Let's go back. Repeat that last argument again.
The quote or what I said after it, because I have to start with the quote to get back on that track of thought, I think.
Go ahead and stop the time, because this is my time now.
Okay.
Your statement regarding how the full natural flow is used, how
Yes.
it's used to alter the projected flow.
Yes.
Go back to that and repeat that.
Okay. Let me start just a sentence above what I think is the real relevant part. So that Mr. Coates in his testimony contrasts the Bulletin 190 forecast flows with DWR's daily full natural flow data, which are not forecasts of future availability. They're calculations performed based on a number of factors. And again, I'm not quoting him exactly here. He lists the factors. Now, here's the important part. Staff only use the daily data to determine which full natural flow monthly forecast is tracking closest to reality for the purposes of predicting full natural flows. Or
Stop. Repeat that sentence again.
staff only use the daily data, and again, I mean the DWR's daily full natural flow calculations, which I must note on the June 12th, the WR48, which is the chart supporting the June 12th notice, the daily calculations end at June 7th. That chart itself explains. So June 7th is the last daily calculation there. Staff only use the daily data to determine which full natural flow monthly forecast, which is the dashed line that curves down, is tracking closest to reality for the purposes of predicting future full natural flows. These notices are predictive tools, and they use the best predictive forecast data from DWR. They don't use the daily full natural flow data unless they use it as a check to see which trend line, because the DWR presents several different exceedance values, percentages. They look at the daily data and determine which of the forecasted lines that the daily data is trending to. As of June 7th, it was trending closest to, and I'm going to forget because there's so much information about this case without looking at the chart. If it was the 50%, for example, they saw that the June 7th, as of June 7th, daily was tracking to 50%, and they used 50% as their predictive tool for the notice of determination that they issued on June 12th. Again, that's not the evidence that supports whether Byron Bethany actually diverted without water that wasn't available to it from June 13th through June 24th. That was just the notice that went out on June 12th. Okay, here's the other part of this same quote that I think Hearing Officer Dodick wanted me to say. So staff uses the daily full natural flows when the daily full natural flow values are higher than the monthly forecast as a predictive tool for these notices. There are times when the daily full natural flows trend higher than what might be the forecasted line. In that case, they're a predictive tool to the extent it's a model, which I don't know what that is defined as in the course. I know that was subject to some testimony, but to the extent that's a model, The division used the daily numbers at times when the forecasted values were 0 or were lower than the daily numbers. That's a benefit to the diverters. As a predictive tool, that gave them more water.
I think we can resume the clock now.
Okay. I'm moving on to an example of this. For the San Joaquin tributary analysis in the summer of 2015, the May Bulletin 120 forecast, which is WR 109, page 4, for the Stanislaus, Tuolumne, and Merced rivers in August and September was 0 for the 50% through the 99% exceedance percentages. However, the daily full natural flow was low, but it was above 0 for most days, some days at least. Staff used the daily full natural flow as the trend to estimate future supply. Now, Mr. Coates also testifies a big question that came up on Monday and has come up, I believe, in these arguments is the 40% that, I'm reminded to inform everyone that the predictive tool, the exceedance values actually include the 2,252 CFS return flow that Ms. Spalletta on cross-examination argued should be added to the June 7th daily full natural flow numbers. Those are, Mr. Yazell has already testified, that return flow number is in the predictive, the exceedance value, that the sloping curved line. This part's important. We're getting into the Delta stakeholders' request
Hold on, let me ask you a question.
Yeah.
That value is included in the predictive curve, and it's the predictive curve that is used by the prosecution team for issuing the enforcement action?
No.
That-
The predictive curve was used
For
to
the
issue
notice.
the notice that went out.
Okay,
That was the determination made by division staff that as of a certain day,
for the notice.
definitively as of a certain day. I mean, there's some argument that maybe in March and April there might not have been water available for diversions too,
So
but
then
definitively,
for my clarification, what did you specifically use for the enforcement action?
well, to issue the enforcement action, I described the investigation that went on and the determination that Byron Bethany on one hand was still diverting up till June 24th, and WSID was diverting or threatening to divert for a number of reasons after May 1st.
But
The-
your enforcement action then is based on the inspection and the fact that they were diverting, and on what basis did you make the determination that they did not have, that water was not available for them to divert?
I think that's a really important issue that is very muddy, has been intentionally muddied, I would argue, in this proceeding. Is about there's a difference between what is at issue when we issue an
Notice.
enforcement action versus the evidence that we proffer at the hearing. There's been arguments in some of the briefing and hearing that the prosecution team has to rely only on the evidence really that we had as of June 12th or as of June 7th. That's not the case. We issue actions based on our understanding, based on the investigations, and the June 12th notice, including the conditions that were predicted in the full natural flow forecast, and the May 1st notice with the same kind of predictions for Westside, that those were true. But we have to develop, and we have developed and presented in our case in chief, and then there's other phases to the case, evidence that demonstrates that the actual diversions that took place, which is specifically a phase 2 issue, were that diversions happened and that they were outside of the scope of their available claim of right. And so we've developed in this proceeding, and I think Water Right -52 is the one that had the chart that has for the full Sacramento and San Joaquin watersheds, has the chart with the full natural flow real data that was measured all the way through, I believe it was August, about the middle of August sometime. And that shows that there was, that the predictive tool was accurate. So we double checked the predictive tool in this 9 months or so since these actions were issued, and have been able to verify and offered into evidence, into this record, in this proceeding, evidence that demonstrates that what was actually diverted, now we have some phases and it's hard to argue something that hasn't been brought up yet, that the diversions that they did were beyond the scope of any right that they had.
Thank you. Go ahead and restart the clock.
Okay, I want to get into the 40% demand reduction into the Delta. Mr. Coates talks about how that came about, and that was the subject of some cross-examination. Staff made that demand reduction as an accommodation to the Delta stakeholders at their own request. And essentially, as we've shown, with pretty minimal backing. They said, we think it's 40%. And staff said, we think we'll take that for now. Okay, that may not be something that happens the next time this has to be done, hopefully decades from now. But we all think it might be sooner than that, I suspect. In order to give every benefit to the diverters, staff applied this 40% demand reduction by either increasing the available supply through an adjustment or by reducing the reported demand. Staff adjusted supply in other ways that they describe in their written testimony in the 1977 report for the San Joaquin watershed. Now, there was some interesting cross-examination and testimony about that 77 report and whether there was return flows for the Sacramento River system, and it was confused by that cross-examination line because it wasn't a complete cross-examination line. The table in that chart talks about the Colusa Basin drain, and as was noted in some of the other cross-examination, there was a presumption in the 77 report that the Bureau would not claim rights to any return flow from its deliveries. Now, as we heard from Ms. Marocco, the Bureau does. So the 77 report does not justify including any return flows from the Sacramento River into this adjustment to the supply or adjustments to the demand. Staff added additional supply for the smaller tribs pursuant to the Department of Water Resources Bay Delta Office 2007 report. Mr. Coates testifies to that. Using the reported demands for either 2014 or the information for the information order recipients or the 2010 through 2013 four-year averages for everyone else, WR78 shows supply and demand analysis for the San Joaquin River watersheds with the prorated delta demand as of August 19th. As shown, after June 12th, 2015, the daily full natural flow dropped so quickly, even into the riparian levels of demand, that there's no way Byron Bethany had water after June 12th to divert. That was its own. There was water in the channel, sure, and we haven't gotten to what that might be. Other parties are going to talk about that, but it wasn't theirs. WR47, which is dated April 29th, that's the notice supporting the May 1st notice, shows that there's insufficient supply to serve all post-14 rights between the 90 and 90% forecasts. That's really significant. The daily full natural flow at that time trended closer to the 99 forecasted line, which means there was only a 1% chance that the forecast might be wetter than what the conditions were showing at the time. Number 48, which is the data or the chart supporting the June 12th notice, shows that the combined daily full natural flow data trended downward at around 11,000 as of June 7th, and the Bulletin 120 forecast was even lower. It was around 9,000 on that chart. The daily full natural flow was higher. Staff used the daily full natural flow to base its decision to issue the notice on that the daily supply trend. Even though it includes the 2252 return flow CFS, it was still 2,000 CFS less than the demand reported through 1902's priority, let alone the 1914 priority that BBID claims. And again, the full natural flow data on that chart ends on June 7th. And Ms. Spilletta in her cross-examination argues that adding CFS to June 7th data and manipulating the demand data otherwise somehow demonstrates that there was no water starting nearly a week later on June 13th. Now, what I wanted to do on redirect was show how adding, even with Ms. Spilletta's assumptions, adding all that CFS, which really isn't justified, but for the purpose of argument, we were going to entertain it. You add that amount to the actual trend line as shown on WR52. You're still nowhere close to BBID's 1914 priority right. So WR52, the one dated August 19th, shows that the daily full natural flow dropped precipitously in mid-June down to riparian levels of demand even before July 1st. That is really bad. This is the chart I was going to add the 2252 to. And we weren't, if offered the opportunity, I'll visually demonstrate that there's no way we were even close to BBID's supply from June 13th through BBID's priority from June 13th to June 24th. WR81, which is the October 7th, 2015 chart, that's the one with the actual flows measured at Vernalis, measured by a gauge, compares that to the prorated downstream senior delta demand, which includes Byron, Bethany, and Westside, including 1902, and earlier pre-14 users. Those are senior to Byron, Bethany, and Westside. That comparison shows that the measured flow, the actual flow, regardless of whether it was full natural flow or not, at Vernalis was insufficient to serve the prorated remaining senior demand for at least June 13th through June 24th. That same chart demonstrates that there wasn't any water available for Westside at any time after May 1st. Mr. Coates' written testimony will confirm all this and that their criticisms offered by their witnesses, which we haven't heard yet, aren't substantial. The daily full and as an offer of proof regarding the rebuttal testimony, I want to talk about that. The daily full natural flow values used by staff to determine whether the Bulletin 120 forecast, which Bulletin 120 forecast to use, and which are not ordinarily used as supply data, does not provide a forecast of water to be expected. The exception is in the case, as I've described, when the daily flow is greater than the forecasted value. And that's when staff use the daily trend for its predictive tool, which benefits the diverters. This is another key point. Staff may not have added downstream contributions to full natural flow values, but staff also didn't subtract from those values downstream depletions, such as evapotranspiration, seepage losses. Thus, while Ms. Spalletta or Mr. Bonsignor in particular argued that additions should be made to the daily full natural flow values, they ignore the reality that nature also requires depletions to be accounted for, which staff omitted from the accounting to benefit diverters as well. We didn't include what might be additional supply, but didn't include additional losses or a kind of demand, not a water user's demand. Staff could have adjusted the daily full natural flow levels with a daily average return flow credit. It would have also had to counter that with a daily average depletion loss. Since
Hearing Officer Dudek, we would like to object to this portion of the argument. Mr. Tariainen is providing testimony to explain what the staff did, which his staff should have been able to explain for themselves. Mr. Tariainen is not under oath, and so he is providing substantive explanatory testimony without citation to the record, which is highly improper.
Thank you, Ms. Spalletta.
This is an offer of proof regarding what we will describe, which is allowed under what should be the guiding procedures for this motion. I mean, this is a very serious motion the prosecution is facing.
Thank you. Objections noted, response noted. Forward.
For the record, Mr. Coates' rebuttal testimony is WR 2010. I'm citing from it. I've cited so far pages 3, 6, and 7. Going back to why the staff didn't include return flow credits, since the daily full natural flow was trending for the most part between 50 and 90% of the forecast, and staff based its decisions using the more generous 50% supply forecast, any net adjustments to the daily full natural flow after taking into consideration downstream depletion losses would likely be greater than the next higher Bulletin 120 supply forecast, which is the 25% exceedance, which is really generous given the way the water year was last year. With respect to ag return flows, Mr. Coates will testify that Mr. Bonsignor provided no additional data to augment supply, and that the evidence of prominent Sacramento River diverters shows that the Sacramento receives minimal return flows as tailwater is often restricted or recirculated in the Sacramento, in reality in 2015. Mr. Coates will testify that for a true demand reduction of 40% to be warranted as the result of pumping excess diverted water back into the source, which was the basis for the Delta stakeholders' request, that returned water must be of the same water quality or better than that diverted, so that it is usable by another party. Mr. Bonsignor merely assumes that all the return flow is of sufficient quality to be usable without a basis. That's Water Right 2010, page 7. Mr. Coates provides two appendices in his rebuttal testimony. Appendix A shows that the May 2015 analysis applicable to WSID would, as Mr. Bonsignor argued, show an excess of 426 CFS at Westside's diversion point only if the 40% return flow credit, which is hypothetical, is applied. Without that credit, there would be a shortfall of water at Westside's point of diversion, or for Westside, of 647 CFS. Appendix B is the June 15th analysis applicable to BBID. Even with all of the alleged excess demands removed, there is still not enough supply to satisfy delta demand through a 1913 priority, with or without the delta 40% return flow credit. Byron Bethany is junior to a 1913 priority. Water supply was that bad. With respect to return flows, Mr. Coates will testify that if return flows were so substantial, there should be evidence of a large return flow component registered at a downstream gauge and available for use, but there was not. Citing his testimony 2010 at page 8, also citing Water Right 251. Mr. Ezel, turning back to the direct testimony, he testifies that he was part of the division to analyze the data and generate water supply graphs, citing Water Right 11. He created WR47, he created WR48. Both graphs show, respectively, that by May 1st or June 12th, water was insufficient to meet the demands of either post-14 appropriative rights throughout the Sacramento River watersheds and Delta for the May 1st, or the demands of appropriative rights with priority dates of 1903 and later throughout the Sacramento and San Joaquin River watersheds and the Delta for June 12th. He's testified that the demand data used in the analysis was collected from the diverters themselves and run through a rigorous quality control analysis to remove excess demand due to over-reporting for power-only use or duplicate data. Up-to-date demand for 2014 was collected from the diverters themselves, some of them, through the information order in 2015, and was incorporated into the analysis. Supplements to the full natural flow forecast he describes were made by adding various tributary contributions under the DWR's 27 report and certain credits described in the 1977 report, as described in Mr. Ezel's testimony. Now, as an offer of proof regarding his rebuttal testimony, Water Right 211, he confirms that every single one of the criticisms raised by the experts hired by Westside or Byron Bethany failed to move the needle. They don't change the end analysis regarding water availability, which is the subject of this testimony because supply in the summer of 2015 was that low. Now, really important, they've made a lot of argument so far about the fact that there was 2015 information order data at some point in 2015 that became available. Mr. Ezel describes and Ms. Maroka testifies on rebuttal that adding that information order data doesn't move the needle to the benefit of Westside or to Byron Bethany. It does not provide water for their priorities in 2015. Now, to some extent, that could be considered an after the fact, as Mr. Kelly described, confirmation bias, but I would just say it's a confirmation. You use the data as you get it, as you can incorporate it, and verify that the notice, the conditions that the staff anticipated as of June 12th were reality. So substituting the 2015 information order data made no difference to the end result. This is going to be written rebuttal testimony. Mr. Ezel also includes every alleged excess demand identified by Bonsignor and Young and removes them from his spreadsheets and reruns all the analysis for purpose of considering whether they would have changed the results relied on by staff when making decisions concerning unavailability, including alleged duplicate demands, data entry mistakes, demands that could not be met with supply in local or sub-watersheds, which was a subject of some cross-examination. His rebuttal testimony shows that even when Mr. Young's identification of alleged excess demands are removed, there's not enough water to meet demand for either Westside or Byron Bethany. I'm done. I'm going to be done in a moment. So the exercise engaged in during cross-examination of Mr. Ezel was really an attempt by those aligned with the diverters to manipulate the data to show that water might have been available to diverters at some time period before the relevant time period, June 7th in particular, using Water Right 48. Had the hearing officers allowed a redirect examination of Mr. Ezel, it would have been shown that both the water supply forecast as well as the daily full natural flow data dropped so precipitously after June 7th. And June 7th was not that different from June 12th. But after June 12th, it dropped off so far that even adding 2,252 CFS of return flow to supply would have made no difference to the analysis or the conclusions today, even if you reduce demand by 740 CFS. The prosecution team's rebuttal evidence will show and does show that all the critiques offered have no effect on the bottom line. Water supply during the drought was that low. For all these reasons, the prosecution team respectfully requests that the hearing officers reject the motion for a non-suit.
Questions, Mr. Taraini?
Have one question that I wanted to ask because I want to see if I can be very clear and specific about this. For purposes of the enforcement action, and let's look at the BBID ACL action, so let's talking about June 13th through 25th, is the best evidence that you're relying on for supply that was available or to diverters, and the evidence that you're relying on to show that water was unavailable to BBID during that time period, is that the daily full natural flow data, or is that the projected forecast?
Daily full natural flow data confirms the projected forecasts. They actually trend very close to the lines that staff picked. But I think it's Water Right 52 shows the daily full natural flow data. So in terms of best, I suppose in a manner of speaking, the daily data is the best information. That's what actually was there, according to the way the Department of Water Resources calculates that. But it validates almost exactly. I mean, very as far as exact can be in statistical and type analyses, that the exceedance forecast that staff chose on the days June 12th and May 1st were correct.
I guess that brings up another question. So I'm not sure, and we've heard this testimony that there's validation. Why are we talking about the predictive trend line if the question before us is whether or not BBID actually had water available to them under their priority of right or not? Wouldn't we look to the best available data, which I think I heard you say was the daily full natural flow in terms of supply?
I think that gets into, Board Member Dodick asked a question earlier about what is the complaint based on and what is the draft cease and desist order based on. And that's based on the information that we have at the time. And at the time that we issued the complaint, what we had was the June 12th notice and the May 1st notice. And then we did a whole bunch of discovery, and other staff continued this task they had of Mr. Ezel and Mr. Coates of gathering the data and putting it together and eventually coming up with a determination of when water was going to be available again, right? Using kind of the same process. But I think more to your question, we have to describe the prosecution team's burden is to show why we issued the complaint and then what evidence supports the findings that we propose in both actions as of the day of the hearing, right, or the several days of the hearing. And so we include and have to describe, which opens to attack the methodology underpinning the June 12th and May 1st notice. And then we have described and included the after-the-fact confirmation based on the best data that we can get, which includes the daily full natural flow. There's other adjustments that staff made that's described in their testimony to things like demand. And we put on our case about that, and then we were challenged, and the rebuttal will show why those challenges don't add up either. So they don't move the needle. When I say move the needle, I mean bring supply up to where either of these right holders would have their priority served.
So, make sure I understand. after issuing the draft enforcement order, staff did a retrospective look at the period of alleged violation and determined, according to what you tell me, that water was not available, and was that determination based on full natural flow as reported or on the forecast? I won't tell you what I think it is.
Yeah, it's the full
It's
natural
the full
flow.
natural, okay, stop.
Yeah.
And did that full natural flow include return flows?
Full natural flow for the water at 52. I think of this one graph that has the daily full natural flow.
Yes. Mr. Buckman, could you put that up?
So one thing about this is this chart, and this is testimony that really the witnesses should be giving, and I may be describing my understanding differently from them, right? This is what I was going to ask Jeff to demonstrate on redirect.
Forget the chart. Okay, let's forget the chart. Just
Yeah.
answer the question for me. When the prosecution team staff did this retrospective look in order to develop the evidence upon which to present to us for the enforcement action, did the supply analysis include return flows? Did the demand analysis include actual demand as reported as a consequence of the information order?
Answers are yes, and I'm going to have the witnesses, give their describe as why. But I want to give a slight preface to that answer, and I think you're presuming to some extent that the staff undertook specific analyses regarding these two diverters, which has been argued by the parties that we need to do. Staff kept doing their job after we issued these cease and the draft and the complaint.
No, I'm not presuming that you took action specific to this discharger. I'm trying to understand, based on your watershed-wide analysis of water availability, what analysis you conducted after the enforcement orders were issued.
They did several. Mr. Coates and Mr. Yazell provide a
I know
number
they
of
did
different
several. I'm trying to
examinations.
understand what parameters, what consideration went into those
Well,
analyses.
they kept looking at the full natural flow,
Unadjusted full natural flow.
making adjustments to the supply, the full natural flow, as described in different ways, and adjustments to the demand as they.
One of the things I kept hearing on Monday was that prosecution staff did not make adjustment to the full natural flows.
So again,
And
that
now
this,
you're telling me they did.
so the full natural flow, I think, are you asking about daily or the monthly forecasts?
No, I'm talking about the daily full natural flow.
Because they kept using the monthly forecasts as available too, right? The charts that they prepared were still there. Those forecasts include the full natural
And why
flow,
would you use
monthly
the
amounts.
forecast looking backwards if you had
Because
data?
their job still, so after they determined that water was not available, they needed to continue the analysis to determine when water was available, and to make the notice that water was. Their job didn't end once they did the June 12th notice. They continued, as they've described, to collect data really daily or multiple times a week and update this analysis. That's part of why we're accused of having so many different spreadsheets and so many different charts that it's confusing. It's because staff kept updating this information constantly in order to determine when water was going to be available again. And that involves the same kind of predictive tool their predictive analysis, which that is what includes the the return flows, the 2252.
The predictive
Okay.
curves.
Yeah, and then the daily full natural flow is really an after-the-fact validation, right? But after the fact comes very quickly, but a day at a time as you go through time. So that's why we have a chart from August where they looked at what the conditions were and how close the daily full natural flows were trending to their predictive lines, and they saw that they were. And in that case, to my mind, that graph that shows the daily full natural flow, even if you add the 2252 CFS to that, it's still nowhere close to where BBID's rate would be, and certainly not where WSID's rate would be for the month of June. And that's the update. Now, the information order demands, the demand adjustments, some of those weren't made until a few months after, even a month or two after we issued these complaints. But again, it was part of doing staff's job. The information order demands, as they were made available, and by August, they were all included in the demand. That's why we have later graphs. The August graph has a demand adjustment that includes actual data and some other information order demand data and some other comments that Mr. Yazell described. And then for the purpose of this proceeding, and it's probably, it's indicative of the burden that's put on the Division of Water Rights staff when we're accused of not doing what would be a permitting water availability analysis for these points of diversions, but instead relying on what we're accused of being is, I don't know if they would say pie in the sky or watershed level conceptual models, but that's what the division's job one is, right? To figure, that's what at least this unit was to figure out when water was not available for water right priorities, and then through the summer and into the fall, figure out when it was going to be available again. And that's what they kept doing. And that's why there's, different analyses from different points in time that we present. If I had technical staff that was available to just prepare a case and not do their job too, maybe the evidence would look different and we would do a site-specific water availability analysis, but we don't have that staff and we're not burdened to do it. That's not our burden. The methodology that staff used in 2015 is both a predictive and a validative methodology that using the actual data that became available since. So
Thank you. Any other questions?
I will email.
Yeah, Mr. Buckman, did you have questions?
I do. And you may not be able to answer these. Specifically, you mentioned WR52. Is there data to support WR52? And if
In a
so,
spreadsheet?
yes. And if so, which one is it?
Well, WR53 has the predictive tool data and the demand data. What it doesn't include, but which is included in the record, and Mr. Yazell, as part of his redirect, could describe how he puts it together and show how he put it together. It doesn't include, unfortunately, the full natural flow data through the middle of August. But that is available in the record. I don't know off the top of my head the exhibit for that, but it's in the record.
Couple more. Just to clarify, I believe you mentioned that when using the 99% exceedance value, you said there was only a 1% chance that the weather would be wetter. Is that correct?
So you're asking me almost a statistics question, and I'm an attorney, and it's been a while.
Okay.
I took those classes. But 99% exceedance means 99% of the time that much flow is going to be available. So yes, 1% of the time there would be more flow available. That's my understanding at least.
And my last question, you talked about the 40% credit, and is it your understanding that you use the 40% credit? Because it sounded to me like you were trying to say that absent the 40% credit, of course, the water conditions would be different, but you did use that in your calculations, correct?
It was used, well, not for May 1st, because the credit came in, I think the meeting was May 12th. That's in the record described by Mr. Coates, where the stakeholders, just proffered this number. So the analysis after that, and I believe the reduction or the adjustment was to demand within the delta, which in effect increased supply by reducing the demand. But I believe that's the adjustment. They may have in different, different ways of looking at the same data may have adjusted it differently, and staff will have to testify to that. But it was not part of the May 1st notice because it hadn't been proffered yet. It was part of the subsequent analyses at the various times. And also, I think you're referring to the offer of proof I made about Mr. Coates's rebuttal testimony, where he said, if you assume this 40%, even with all of these assumptions that one of the other side's witnesses makes, you still have to assume the 40% return flow credit in order to move the needle above West Side for May, I believe is the argument that was made.
But you did include that 40% in your analysis in June.
For the June 12th analysis, yes. Everything after, that May 12th meeting or whenever staff got to include it in their different databases.
One more question, and I'm trying not to beat a dead horse here, but Mr. Coates in his testimony regarding the Bulletin 120 forecasts says that when you look back prior to April, that the data for the different exceedance curves are all the same. And the reason for that is what's done is done. So looking at August in WR52, I'm a little confused, and maybe you could explain it to me why the forecasting data for the different forecasts, the different percentage of the exceedance forecasts are still different. Because it would seem like at that point what's done is done, and there should be an actual data set of what was actually the supply at the time.
I can only offer you my understanding about that. You'll have to confirm that with staff. But it was a validation of the exceedances that they chose to use. The Bulletin 120 forecasts are only that. And Mr. Nemeth described, or in his written testimony at least describes, that once the month goes by and they get the actual data, or that's where their tables, all the numbers become the same in the tables that we show. There's several tables, right? But for each watershed that there's a forecast done for. Yeah. After sort of the fact review of their analysis and of their methodology, I believe staff just left the original predictive lines there. The predictive lines do shift over with some of these later charts, right? But they leave them there, I think, to validate so that the daily full natural flow, they can see where the trend line was and whether their analysis correctly, they correctly chose the right forecast line. So it's not so much an ex post facto rationalization of what they chose. The full natural flow, is what it is once it's measured, and they use that to compare to what they had used as a predictive tool in the past, and then that helps determine whether it's a good predictive tool in the future. All of this is, in the testimony and on rebuttal.
Well, sorry if I may. This is WR52, and this is through September, it looks like. And I'm looking at the forecast for the adjusted 50% in June, and it looks like it's under 10,000. And then I'm looking at WR48, and it looks like the adjusted is definitely over 10,000 CFS. I guess that's where I'm a little confused.
Staff will have to describe, I think their testimony describes that June 8th data point from DWR. But if you go back to the 52, you see that the trend line was, that the actual readings were nowhere close to what that DWR proceeding was.
But I guess my question is, if what you're saying is the trend lines, once you adjusted it, are the same looking backwards, then shouldn't that be reflected?
I would, At this point, and I've done this in my argument, suggest that maybe you should be asking the witnesses this. There was an opportunity for hearing team questions at the close of their case-in-chief presentation, and maybe some of these issues weren't exposed on cross-examination, right? But under the applicable standard, that's all the more reason to deny the motion and maybe call them back up and ask them these questions themselves. I am not testifying. I have not taken the oath, and I won't. And I can only describe to you my understanding, which at times might be fuzzy when I'm standing up here for an hour presenting.
All right.
So,
Thank you, Mr. Tariani.
and I understand that the attorney for the Department of Water Resources would like the remainder of the time or a portion of it.
All right. And then Mr. Kelly, Ms. Splett, I know you're eager to provide your rebuttal, but I'm going to have to take a 5-minute humanity break after this.
Sure you don't want to do that before? Robin McGinnis for the California Department of Water Resources. DWR joins the prosecution team's arguments, especially the proper standard and the correct section of the Code of Civil Procedure here. CCP 581C and related case law provide the standard. The prosecution team's evidence gets every credible inference on this motion. The point of the hearing, all phases of the hearing, is for the parties to present their evidence and allow the hearing officers to weigh all the evidence. The point of this motion is for the hearing officers to view the prosecution team's opening statement and the evidence that was admitted on Monday. The moving parties are asking the hearing officers to consider evidence that's not in the record, including a right to divert project releases that have been abandoned, and that the delta is a source of water, points which DWR and other parties dispute and haven't been given an opportunity to submit evidence on. DWR's written exhibits that we submitted show there is no water stored in the delta. It is not a source of water. DWR's testimony also shows that illegal diversions during extraordinarily dry conditions like 2015 caused DWR and reclamation to release more water from reservoirs than...
Ms. Doduck,
We
Tim
object.
O'Laughlin, San Joaquin Tributaries Authority.
Mr. O'Laughlin.
I'd like to object to this statement right now because the witness yesterday, Ms. Moroka, said that nothing having to do with DWR or reclamation stored water releases was the basis of this complaint. So therefore, this offer of proof or testimony is entirely irrelevant to these proceedings.
Ms. Splett.
Central Delta joins the objection. This was actually the subject of one of our motions in limine to strike the Marshall testimony. And in fact, this was the only portion of the motions in limine, as I understand it, that was granted. And the rationale for granting the motion was that DWR had an obligation to put forth any evidence regarding alleged injury in a case in chief, which it failed to do.
Mr. Kelly.
Yes, Hearing Officer Dodick, thank you. Daniel Kelly, BBID. I join on that objection. Not only did Ms. Moroka testify that stored water was not involved in this proceeding at all, we have also that is confirmed by her deposition testimony, and we can provide that to you, where she also swore under oath that in this proceeding, that the Byron Bethany Irrigation District was accused only of taking water that was needed for more senior pre-14 water right holders and riparians, and that stored water was not at issue in this proceeding. And so I also object to any offer of proof or testimony or evidence with respect to stored water.
Thank you, Mr. Kelly. Ms. McGinnis, response?
This is not an offer of proof. I'm responding to arguments the parties made this morning. If we look at the slides that were presented, on one of the first slides, they mentioned stored water that has been abandoned, which DWR and other parties argue we just don't abandon water. We haven't been given an opportunity to argue
Fine.
this.
Go ahead and proceed, and I'll take all the objections under consideration.
So let's see. I'll skip the other factual arguments that I was going to make and hit on procedure instead. These enforcement actions are about whether BBID and WSID diverted water illegally. They are not about the board's water availability analysis that supported the curtailment notices. The water availability analysis was part of the board's investigation. the administrative civil liability complaint to BBID, and the draft cease and desist order to WSID. But that's not all these actions are about. We haven't yet heard from key witnesses, the engineers with the Division of Water Rights who were assigned to investigate the diversion and use of water by BBID and WSID. On Monday, the prosecution team agreed for convenience to call these witnesses, Paul Wells and Kathy Baer, in phase 2. Quoting from Monday's transcript, if the parties are willing to agree not to object to us putting on evidence about how much Byron Bethany or WSID diverted during the relevant periods during phase 1, we can skip the rest of our phase 1 presentation. And last, as a policy matter, I would request that if non-suit is granted, the board begin immediately the task of creating a rule for determining water availability for water right holders within the basin, and that it include water for meeting downstream objectives. Thank you.
Thank you, Ms. McGinnis. Mr. Kelly?
Bring us our Duduk. If I
Hold
can
on.
very briefly
Stop
save the
clock.
20 seconds. For the purpose of this, BBID will stipulate that it diverted water in the period of the alleged violation for the purposes of what's going on here, because I don't want that to confuse the issue. So I'm fine if you assume that BBID diverted water during that window for the purpose of the consideration of the pending motions.
Thank you, Mr. Kelly. Ms. Ainsley?
This is just a brief objection to follow up with what Ms. McGinnis was just saying. We solely want to object to the allegations that I believe Ms. Spalletta brought up earlier, which have been now kind of carried through these whole arguments.
Excuse me.
That stored
Chairman.
water, excuse me.
Mr. Laughlin?
Yes. Is this part of the total 45-minute time period?
This
Yes,
is part of
it's
their
fine.
45
I'm
minutes.
fine with that.
Which is down to like 20 seconds now.
I've got one sentence,
Okay.
so I'll start over. What we object to was the allegation that stored water supply should have been supplied in the calculation for water supply. It's not a part of available water supply to these parties. Thank you.
Thank you. All right, for humane reasons, we're going to take a 5-minute break. Michael, what's the status? We're okay? All right. Can everyone please come back in? We're missing Ms. Spalletta?
We are, Hearing Officer Dodok, just a kind of a procedural issue. Ms. Spalletta,
Oh,
no,
not yet.
we don't need to be on the record for this. Ms.
She's right
Spalletta,
there.
Okay, somebody apparently came into the room, tossed a
Yes,
backpack in the corner.
we have identified the person.
We know, okay, that's what we wanted to make sure. Thank you.
Spalletta, now we are back on the record.
Thank you. First of all, I'm going to address.
Put our microphone.
Thank you.
And timer.
First of all, I'm going to address just some basic legal issues. There was an argument that the proper standard that applies to this case is in CCP 581C, and there's a variety of deference afforded. There is some deference afforded, but that is not the correct standard. That is the standard that applies to a motion for non-suit made after a party's opening statement in a jury trial. The proper standard in this proceeding at this point is the motion that's made after a party has put on their case in chief. And that is the one that we cited, which is CCP 638.1. Historically, both were called a non-suit. In modern times, the one we're using now is actually more appropriately referred to as a motion for judgment. Mr. O'Loughlin used the old-fashioned term when he asked for it yesterday. But it is actually, the terminology is not controlling, and there is case law on that point, which is Commonwealth Memorial, and the case is 1976-63 Cal App 3rd 867. So again, standard was not cited correctly. There's also two other cases that Mr. Tarianen cited about the impropriety of using the non-suit in this context. Both cases are incorrect. I'll note for you that Mr. Knapp from the City of San Francisco was kind enough to point to me California Public Utilities Commission decision recognizing the use of non-suit in administrative proceedings. That's Southern California Edison Company, decided July 1987, 25 CPUC 2nd 91. And in fact, the case that Mr. Tarianen cited, City of Oakland case, was not a case that said non-suit was inappropriate. It said that in that case, a statute of limitations defense was inappropriate in an administrative proceeding, and the defense was raised in a motion for non-suit. So the case was about whether you could plead statute of limitation as a defense, not whether you could use non-suit. Okay, let's talk about the substance. Mr. Tarianen has basically stood up in front of you and said, my witnesses did not present to you a complete case of why water was unavailable and why their methodology was appropriate. We're going to do that later in rebuttal. That is a huge procedural problem. These parties and their counsel have been working for over a year to understand the basis of this methodology. And here we are after the case in chief, and we're being told we haven't heard all the evidence. They want to put that evidence on through rebuttal, in which case we have no opportunity for our experts to review it and respond to it. That is a serious procedural due process violation. We could rest our case today. WSID and BBID could rest our case today, and they would have no right to put on a rebuttal case, and you would be stuck with what they've put in front of you already. That's how the procedural rules work. The other argument Mr. Tarianen made to you was that you don't have the ability to use this motion to control these proceedings. That's a very dangerous argument for him to make. You're the state board. You're designated as the hearing officers for the state board. You have the discretion to control how these proceedings work, and you have a public policy duty to do them in a way that's fair and logical and gets to meaningful results. If this case is not going to meet that public policy duty, then you should tell the prosecution team the job wasn't good enough and they should try harder next time. You should not waste the time of all the people in this room for the next 2 weeks. You have the discretion to use the motion. We were thankful that you gave us the opportunity to explain why it should be used, and we urge you to use it to do the right thing. Finally, I want to talk about the evidence. You asked point blank, many of you, what was used to determine unavailability for the purposes of these enforcement proceedings? You did not get a straight answer. They are now saying that it was daily FNF that was plotted on the after-the-fact graphs. That's what Mr. Tarianen just explained. Their witnesses admitted that that daily line, even on the after-the-fact graphs, never included any of the adjustments, and we've given you those citations. It didn't include the adjustments for flows, not return flows, but flows in the unimpaired flow subbasins in DWR's 2007 report.
just basic regular flows that are designed to meet demand. They admitted they include all the demand from those subbasins and none of the flows in that blue line. They've also admitted they didn't include the return flows in any of those blue lines. So if that's the reason, then that blue line is still a major problem based on their own testimony. What's also really scary about what Mr. Tyranen just explained to you is it directly contradicts with the prosecution team's written testimony on direct. Kathy Maroka's written testimony on page 3 says she is the prosecution team lead and the water unavailability determinations for the purposes of the 2 enforcement actions are based on the May 1st and the June 12th analyses. That's what she put in her written testimony. Now Mr. Tyranen tells you, oh, well, not really. That's when we were just still kind of learning. So we have some after the fact stuff, and I want my witnesses to be able to come up in rebuttal and kind of explain the nuances to you. No, that would contradict with what their prosecution team lead said was the basis for these enforcement actions. We cannot have meaningful and legitimate enforcement proceedings in this forum where someone gets to hide the ball. That's wrong. These people deserve to know what the evidence is against them. It should have been presented at the time the draft CDOs were sent to them. If the evidence wasn't ready at that time, they shouldn't have been sent. There was no reason for those letters to go out in July if the evidence didn't support it. Staff should have taken the time to do the right analysis, send the analysis to these people with the draft CDOs saying this is what your draft CDO is based on, and given the parties a meaningful opportunity to review whatever the evidence is that they're going to rely on. But they waited, and in January, we finally got the first written explanation, and it says based on May 1st and June 12th, and that's what they put on in their direct case. And now they want to come in and say, well, not really. We have stuff after the fact that we can explain to you too. That is a huge procedural problem. And I urge you not to let the prosecution team conduct an enforcement action in that fashion. Finally, I'm going to point you to what Mr. Tyranen accused me of being less than truthful with you about, which is page 219 of the transcript. That's when Mr. Yazell made the admissions about what happens to the daily full natural flow line when you make the adjustments, just the 2 adjustments we were talking about, not including all the other issues. My specific question had nothing to do with June 7th. I asked him, let's look at the graph, Exhibit 48. We just went through an exercise where we established that if the blue line had been adjusted to reflect your return flow of 2,252 CFS, that would actually be hovering right there along the top of what you depicted as the demand in June. And he answered yes. And this brings up the whole issue of why these graphs are so misleading. Demand was depicted as a monthly time step block. Supply was actually calculated as a monthly time step, but then graphically depicted differently to make it look like there was a discrepancy. If you take that full natural flow line that absolutely does drop off after June 12th and you average it out onto the monthly time step, it proves our case. But that should not be your job here. That was the job of the prosecution team. It was their job to present you with credible, logical evidence, and they didn't do that.
Thank you, Ms. Valera. Thank you all. We will now take a break. I can't predict what time we will come back, but we will certainly let you know by noon what the next steps are. Mr. Kelly?
If I may, very briefly, I talked to Mr. Taryainen a bit this morning, and to Ms. Ainsley about witness availability. We've been thrown for a little bit of a loop by the delay. As I explained to you on Monday morning, Dr. Polson is unavailable tomorrow, and I understand that Dr. Hutton is unavailable Friday and all of next week. And as it turns out, Dr. Polson is probably also not available next week. And so we now have some very significant scheduling problems. I promised Mr. Taryainen and Ms. Ainsley that I would confer with them in good faith to kind of see what we can do about at least the rest of phase one. But I'm concerned that because some witnesses need to be here to hear others, I know Dr. Hutton wants to be here to hear Dr. Polson, and we want Dr. Polson to be here to hear Dr. Hutton, that matching their availability now is going to be near impossible for the rest of this week. And given Dr. Hutton's unavailability next week, we have real serious scheduling difficulties. And so I'm committed to work with Mr. Taryainen to try to resolve that, but I want to let you all know that we do have those pretty significant problems now with scheduling. Thank you.
Just for my information, are both, I see Dr. Paulson, both Dr. Paulson and Dr. Hutton here today and will be here the rest of today?
Yes, we can have Dr. Hutton here the rest of today, and yes, he'll be here today.
But Dr. Paulson will not be here tomorrow. Not tomorrow morning, but you can be here tomorrow afternoon.
Since she doesn't have a microphone,
Yes.
Dr. Paulson has indicated she can probably get here by around 2 o'clock tomorrow afternoon, given the flight schedules.
And Dr. Hutton will be available tomorrow? Okay, but not next week,
No, not next week,
and not Friday.
and not Friday.
Thank you. Let's go back on record. Is that? Thank you, everyone. Oh, the prosecution team is late. Are you here for the prosecution team?
Yes, the rest of the prosecution team is on their way. If you could
But
please.
since you are here representing the prosecution team, I am going to proceed. Right? We recognize the gravity of the request made by the moving parties, and we have the flexibility to structure our proceedings and adapt as the proceedings develop. In reading the transcript, it's now clear to me that there was some confusion about the offer of proof for redirect. So before considering the request, we think it is appropriate to allow redirect and recross. We will begin promptly at 1 p.m., and we are most interested in this one issue. What is the best evidence of actual supply and demand available now during the period of alleged illegal diversions? We will allow the prosecution team time for redirect, other parties time for recross, and actually, let me clarify that. For redirect and recross as a group, not per individual party. And at the conclusion of those arguments, we will allow for each side to have 5 minutes of concluding comments before we take this matter under advisement. And please let the prosecution team leader know we will begin promptly at 1 p.m. Ms. Spalletta.
I'm sorry, I may have missed it. Did you say how much time each group has for the redirect and the recross?
I'm not setting a time limit at this time. It's important for us to fully understand this issue, but we do, as always, expect efficiency. With that, we will
Officer Robin McGinnis for DWR.
Ms. McGinnis.
I'm just what you said the groups. I'm wondering who is in each group.
There are groups that presented their arguments this morning in favor of the motion and objections to the motion. Not seeing any other hands, we will reconvene at 1 p.m. Thank you. right, everyone, please take your seats. It is 1 o'clock. I am resuming. All the previous announcements stand, including making sure your cell phones are on silent. We will begin with the prosecution team and their redirect. Again, I will remind you that we're focused on the issue of the best evidence available of actual supply and demand during the period of the alleged illegal diversions. Mr. Tariainen.
Hearing Officer Dudek, can I just get a clarifying question?
Kelly?
Is it the best evidence that was contained within their direct testimony submittal? In other words, if they think there's better evidence now that was not provided as part of the direct, are you asking to understand that as well? Or is this just the best evidence that was contained in their submittal?
I will ask them to clarify when they present their evidence.
Thank you.
Thank you, hearing officers and members of the hearing team. First of all, I want to apologize for missing the noon update. I was tardy. I take full responsibility for that, and it won't happen again. I've called, Ms. Maruka, please come up. As I understand the scope of the redirect, based on the question that you presented, I've brought all three of the relevant witnesses back up for redirect.
And for the record, they did take the oath on Monday.
Okay, so do the three of you understand the question presented? And if I may paraphrase the hearing officers, what is the best available evidence that you would look to today to determine supply and demand during the relevant violations periods? Hearing officers, have I conveyed that correctly?
What is the best available information for us to consider in determining the actual supply versus demand during the period of the alleged illegal diversions?
Okay. Let's start with the end point first. Ms. Merkel, or anyone on the panel, what are the dates of the alleged violations for each matter? Just so we can...
So for WSID, it would be any day after May 1st, so May 2nd through November 2nd. For Byron Bethany, June 13th through 24th of 2015.
Thank you. Let's turn first to supply. And for anyone, what would the best available supply data for those days be?
Okay, so as of today's date, that would be the daily FNF data.
FNF data from
June 13th through 24th for Byron Bethany, and from May 2nd through November 2nd, 2015 for Westside.
Where would you go to find it?
DWR's CDEC website.
This question may be for Mr. Yazell. I believe your testimony on the case in chief was that you are the person who goes and gets that data.
Correct.
I'm sorry, could you repeat that last question? I didn't hear you.
And maybe let me phrase it as an open-ended question too, appropriately. How do you obtain the supply data?
On a frequent basis, I go to the appropriate station IDs at the CDEC website and gather the daily FNF data and compile it into a spreadsheet.
A frequent basis, how often is that?
Anywhere from daily to once or twice a week to weekly, depending on when the data is updated.
How often have you been doing that?
Pretty continuously since well before April, and I'm still doing it on a
Well
frequent
before
basis.
April
Of 2015.
15. In your experience with the department's full natural flow daily data, is it updated once posted?
Occasionally. It's not more, less often than not, or very infrequently.
Very infrequently. And so you have observed updates, or you've noted there.
I've seen changes in the numbers on a given day, yes.
How long does it take for updates to happen?
Usually after a 2-week period, they're pretty steady after that. I don't see any changes after 2 weeks. Meaning if after anything 2 weeks previous or after 2 weeks later, it's consistent. I don't see any changes.
And when you do your updates, which you described as frequent, how much data do you gather?
I usually verify those previous 2 weeks. So usually I'll go back and double check, 2 weeks. If I get, for instance, if I got data today, I would also review the previous 2 weeks to see if anything changed, and I would make those changes.
Say that last part again, just a little louder. I want to make sure the record clears it.
As an example, if I collected data today, usually it's if I collected data today, there's usually a couple days lag, so I would get data. So the data on the website would maybe be, available for 2 days prior. So I would gather that day's data, plus just confirm that nothing has changed for the previous 2 weeks worth of data.
Okay. Let's look to the Byron Bethany violation period, which we just heard June 13th through June 24th of 2015. Roughly, when would you have expected the last updates to the Department of Water Resources daily full natural flow data for that period?
Within 2 weeks, definitely any time after that.
So
on
the calendar-wise?
I don't have a calendar in front of me, so 14 days after the 24th.
July.
Sometime in July, yes.
Were you getting updates in July of 2015?
Specify updates?
Oh, pardon. You described a few moments ago your frequent updates of the full natural flow daily, would you call it a database that you keep, or a spreadsheet?
Yeah, the spreadsheet.
You described that you update it frequently. Were you updating it during July of 2015?
I was adding new data to it, yes.
Then when did, I don't want to speak for you, but I recall a few minutes ago you said since about April of 2015 you were obtaining the daily data?
Correct. It was probably earlier, but
okay.
Well, I'm sorry, it would have to be at least March, because at least our graphs begin in March.
From that April or March period that you just described to now, did you have any periods where you weren't updating the data?
No, I have a complete daily record from then until today.
Take any vacations in that time?
Yeah, I come back and yeah.
Not relevant, I'm sorry. But I believe you answered, repeat the answer though.
Yeah, I have a daily record, a complete daily record from March until, well, actually I think more like the 20th of this month.
But based on your updates?
Yes.
Okay. In this proceeding or these proceedings, you've submitted written testimony, correct?
Yes.
What phases or what segments, I guess, have you submitted written testimony?
Primarily describing how I compile.
I'm sorry, my question really was, maybe I'll be more direct, but leading slightly. Did you submit testimony for phase one, which is?
Yes.
And did you submit case in chief testimony for phase one?
Yes.
Rebuttal testimony for phase one?
Yes.
Not offered that. That's the lawyer part. That's not a question. In your submittals, and I'm talking about the universe of the submittals that you've made, have you included a database of the full natural flow daily calculations?
Yes.
And whether it's case in chief or rebuttal, what would the most recent date be of the full natural flow calculation updates?
As far as this, the spreadsheet that I've submitted,
Yes.
it's in sometime in August. I don't know the exact date.
Time in August. Have you submitted anything with full natural flow data for after August?
Yes.
How far?
That would be through October 31st. That's
October 31st.
Yes.
Okay. Do you recall, I won't ask you to remember the exact exhibit number, but do you remember whether it was case in chief or rebuttal?
which
For the daily full natural flow through October 31st.
for October 31st, that's in my rebuttal.
And for your case in chief, did you submit a database of daily full natural flow calculations?
Yes.
And how late did that go?
That is through around August. I'm not too sure the exact date.
Okay. But between the evidence that you've submitted, you have through October 31st.
Yes.
Do you have any reason to believe that there would have been additional updates to any of that information for the period through October 31st?
No.
So the general question is, what would the best available supply data be for June 13th through June 24th? And Mr. Coates, I believe, I don't want to speak for you, but you've answered the daily full natural flow calculations.
Correct.
Are those, based on what Mr. Yazell has just said, or anyone can answer, including you, is that information in the record for phase one that we've submitted but not submitted for the record yet?
Yes, it is.
Let's talk about demand. Oh, pardon me. Let's talk about West Side. I believe one of you, maybe it was Mr. Coates, testified that the relevant violations period for West Side was what again, please?
May 2nd, 2015 through November 2nd, roughly 2015.
November 2nd, 2015. So do we have that entire record for daily full natural flow in the record?
Through October 31st, as Jeff Yazell just said.
So we're missing some days?
A couple. November 1st and 2nd.
Okay, thank you. Are the daily full natural flow readings available on a public website?
Yes, they are.
That website?
The Department of Water Resources CDEC website.
Have you provided the URL for that website in your testimony, either of you or any of you?
I have. This is Jeff Yazell.
Does your testimony describe, do you just go to one page to get it?
At the time, there's a separate webpage for each river station, each CDEC station.
I don't want you to restate your testimony, but does your testimony describe the process that you take to get each of those stations' data?
Yes.
As a technical person, would you expect another like-minded technical person to be able to review your testimony and go to that public website and get the data for November 1st and 2nd?
I believe so, yes.
Let's turn to demand for a moment. Again, not to restate, but the relevant periods we're interested in are for Byron Bethany, June 13th through June 24th, and May 1st through November 2nd for West Side. Let's focus on Byron Bethany. Again, this has been offered before, but I'd like somebody to answer. What right priority is the Byron Bethany claimed right?
They have a, I think it's an August or a May 1914 priority. I can't remember exactly which month.
That be considered a pre-14 right or a post-14 right?
It's a very junior pre-14 right.
Okay, so in the universe of pre-14 right priority, what are we concerned with in terms of the Byron Bethany right for what rights would be senior to Byron Bethany?
It would be anyone with an earlier priority on pre-14.
Priority.
And also, I'd like to add, and riparian rights.
And riparian. That raises an interesting question that I'd like to answer. And I don't know if you can answer very specifically, but I know you folks have had some experience looking at this database. Have you run across any riparian rights with a priority date junior to 1914? And this can be outside of the scope of this proceeding, just ever in your professional career.
I'm not familiar with any.
And I have not yet, we received a lot of deeds and other information in response to the informational order, but we haven't completed our review. So as the status of that review is right now, I'm not aware of it.
You say informational order, what do you mean specifically?
The informational order that was issued to 90% of the larger senior diverters in the Delta, we asked that they submit their information to document basis of right, and that included extensive information. It was gigabytes of information. So there may be materials in there that are responsive and describe, the seniority of the rights. But because it's gigabytes and we were occupied with the Delta, the drought work, we haven't finished our review. So we may have such information, but we haven't reviewed it.
When did you issue that order?
May, right?
No, the informational order was issued in February 2015.
When did you receive the data that you just described? The deeds, I don't want to...
We started receiving, all of that data was due by March 6th, but there were some parties that received the order that indicated they wouldn't have a complete submittal, but I would think by April 6th we got most of that information.
April 6th of 2015.
2015, correct.
And Ms. Maroka, you, I think, started describing this. Have you set up a process or assigned staff to review the data that came in?
Yes, I have. And so as my staff was relieved from their field inspection duties for the drought, I have had them move to reviewing the informational order materials. Earlier than that, I borrowed staff from somebody else and had them putting all those materials into spreadsheets and doing other tasks that didn't require a lot of technical knowledge and technical background. But now that my technical staff were coming out of the field, I had them working on the technical aspects of that review.
So that review's underway.
It is.
Hypothetically speaking, might you find a riparian right that is junior to a pre-14 right?
I may.
You expect to find?
It's very possible. I don't know the likelihood, though. I couldn't.
Expect to find a significant number?
No, I would not.
Okay, let's get into more specifics about demand. And I think to do this, I want to start by a reference, and that is the demand that was used. Let's talk about the June 12th date, but we'll talk about the rest of the demand or how that gets updated soon. But just for a reference point, on the chart, it's WR 48, as I recall. there's a list of, for demand. What was included in that? So we can talk about how you may be updated or might update it now.
June 12th. That was the riparian and the pre-14 demands. The average 2010 through 2013 demands plus the 2014 demands for those that reported under the 2015 information order. Yes.
Can one of you, maybe it's Mr.
I'm sorry,
Coates.
let me stop, make sure I understand. Could you go ahead and put that up, Mr. Buckman? So you're saying the demand reflected on this chart is a demand as reported from the informational order?
Let me answer that. Okay, so the informational order required them, the recipients, to complete their 2014 actual uses in advance of the June 30th, 2015 date. So that was done. In addition, it also asked them to project their 2015 entire year, along with once an actual amount of water had been used for a month, the following month on the 6th, in arrears, they were required to report that.
Okay.
So this graph has their 2014 actual use, which was due March 6th. So by this time, we had all that data incorporated in there.
Actual demand from 2014.
2014, which was the last year's use, correct.
I just want to make sure to clarify what recipients, who received the information order?
So the informational order was sent to, I think, around 1,061 statement holders, which are riparian and pre-14 claims of right in the Sacramento, San Joaquin, and Delta watersheds, the top 90% being the amount of reported use.
Top 90% by volume.
Correct.
So as this reference, maybe for the next, Mr. Yazell, you've described a number, and I won't ask you to restate them, and I won't restate them, but your testimony describes adjustments to demand.
Correct.
And would this demand information have been subject to adjustments? I won't specify, I won't ask you to specify.
Yes.
Can we see WR52?
Sorry, before you move off this chart, the demand reflected here is demand from 2014 as reported as a consequence of the informational order, and this demand has also been adjusted.
Thinking, okay, so the original demand was the average 2010 through 2013 for everything. That was the starting point as the original demand. For this particular graph, just for those who reported under the information order, their demands, their average 2010 through 2014 demands were replaced with the actual 2014 demands. That represent that. So
What is on this chart that reflects demand?
the shaded areas.
And that demand is the demand from 2014.
It's a hybrid. It's for those because.
So
I might be able to ask a clarifying question. Brian, you just said that only the top 90% by volume got the information order.
Correct.
Where did the data for the rest of the seniors come from? And by seniors, I mean pre-1914 and riparian.
That was their 4-year average.
What 4 years?
From 2010 to 2013.
Where did you get that from?
That was from ERIMS.
So this data includes for the bottom 10% by volume of those senior demand claimants, this 4-year rolling average from ERIMS.
Correct.
And it was, describe then what you did with the 2014 demand data from the information order.
So then I replaced those who reported for the 2014 information order, I replaced their average demands with the 2014 reported demands.
Another clarifying point. When do these senior right holders, and Brian, I think a minute ago you mentioned they're called statement filers.
Correct.
When do they file their statements?
Those statements are due every 3 years, and they're due on June 30th of that particular year.
All of them submit a statement on the same year?
No. A third submit on 1 year for the 3 years past, and then it rolls every year for the next successive 3.
But the top 90% by volume that received the information order, was that sent out to people based on when their next statement was due?
No.
Got it. So whether they
Correct.
needed, they don't want to be testifying or asking two leading questions, but would everyone of the top 90% by volume of the senior right holders have been expected to submit that data in 2015?
Yes, if they were.
Pardon, without the information order.
No. Just a third, correct.
Another third.
But even then, those that submitted on the third weren't expected to submit it in advance of the June 30th deadline.
Without the information order.
Correct.
With the information order, you got more demand faster.
Exactly.
That 2014 demand data for those recipients who received it, and let me risk paraphrasing some of your testimony, who received it and had responded by this date. That's what's included in the demand?
Yes.
Jeff, when you say other adjustments, I think your testimony talks about, removing duplicates in power and things like that.
Correct.
This demand database that this information was pulled from, is that the same database that you would have the post-14 rights in?
Yeah, the entire data is set as there.
So in theory, you could put post-14. Let's, for example, bring up WR47. And then what's the big dark shaded area?
That represents the post-14 demand.
So you pulled it from the same type of database?
Correct.
Back to the 48, please. Okay, so now we have, I think, hopefully a good basis for what the demand was for June 12th. And let's talk about how you would be able to update it today. Brian, I think you mentioned it, but I want to make sure we're clear. What actual diversion data after 2014 did the information order recipients need to submit?
So they were required to submit 2 things. One was their projected use and then their actual use on a monthly basis.
What is their projected use and when? Compound question, but what is their projected use?
So by March 6th, those in receipt of the informational order were required to submit the 2015 projected use by month for the entire year, and then as a qualifier to make sure they report their actual use a month in arrears due on the 6th of every month.
Say a month in arrears, it's due on the 6th. What month would they be submitting the data
So
for?
if they had actual March data, they were required to actually report that by April 6th.
By data, you mean their diversions for March?
Correct.
So you received, talk about what, maybe, I don't know if you have a percentage-wise, but did the information order get a big response?
I think we had a very large response, yes.
Percentage-wise?
Not the exact percentage, but I want to say over 90%.
And with the monthly ongoing diversion data reporting, did that level of reporting percentage continue?
I'll have to let Jeff answer that.
I believe so, yes. There may have been a month here or there missing, but yes.
I'm
Individual.
specifically talking about May 1st through November 2nd, and then specifically within that June 13 through June 24th.
Yes.
Okay. Now could we look briefly, unless there are any other questions on this one, can we look at WR 52? Okay. And I think this question is for Mr. Ezel. Mr. Ezel, first of all, what is the dark shaded area represent in this?
The upper dark shaded area, that's that represents the pre-14 demand.
And below it is the lighter shaded area.
That's the riparian demand.
Is the demand, I'm gonna talk about it graphically, but I think we're talking about the database that underlies the graph. Is the demand the same on this chart as it was on the June 12th notice chart that is WR 47?
No.
Different.
It's different.
What is different about it?
As I stated in my testimony on Monday, that incorporates some additional adjustments that were missing from the June 12th data spreadsheet.
Adjustments from relative to what?
Oh, from stakeholders' requests, and also I removed some revoked or inactive demands that were identified as revoked or inactive since I created the previous RUDS data set.
When did you make this? When did you make this demand database?
The underlying demand database?
Yeah.
That was the June 15th version, I believe.
Okay, so even though this chart is marked as August 19th, and I'm looking in the lower right-hand corner of it.
Right. The underlying demand data is the June 15th.
Pardon, okay. Oh, June 15th, and you, forgive me, why is it the June 15th database?
That supersedes the June 9th data set that I used for the June 12th graph.
I believe you explained this.
I explained this in my testimony on Monday, yes.
I don't want to quote you, but it was overwritten by June 15th.
Correct.
Other than these adjustments that you did to this, was it different in any way from June 9th? The demand side.
The demand side? I don't believe so.
What I'd like to do now is ask Mr. Ezel to eyeball what it would look like if we added 2,252 CFS to this. And what I would, first of all, talk, Mr. Ezel, when you were cross-examined on Monday regarding WR 47, can we go back to 47 just briefly? 48, that's right, you had it right, I'm sorry, I was wrong. What is the latest day that this daily full natural flow plot has?
June 7th, 2015.
Can you roughly estimate where that is?
It was 11,000-ish, somewhere.
Add 2,252 to 11,000.
Can't do math under pressure. 11,000. About 13,250.
And can you, I know we're eyeballing, and maybe Mr. Buckman, if you can zoom in on the part of June where it says pre-14 demand through 1902, can you eyeball where that red dashed line is?
Just around 1370-ish, somewhere between 13,000 and 14,000.
Say 13,750 maybe? I don't want to speak for you, but. Okay, very roughly then, Ms. Spalletta asked you to subtract, I believe it was 740 CFS from that demand amount.
From
red dash.
The red. Okay. want me to do the math, or are you asking me to?
If you need to, but you said, I think between 13 and 14,000, or
Right.
13.5 and 14,000, I think is what, I don't remember exactly what you said, but
So say 13,000 minus 750.
I actually think I might have lost the question. Can I get a clarification on the question?
let me go.
Yeah, and I think the pointer's in the wrong spot, so
Yeah,
it's
yeah,
confusing things.
Well, what we're looking at is, if you could zoom in on, center on that, where that little arrow that says pre-14 demand through 1902 is coming down. What month is that? Does that represent?
That is June.
So where the chart says pre-14 demand through 1902. And Mr. Buckman, would you scroll down just a little bit so we can see white above the top of the burnt orange? Other direction, please. There we go. Let's look at this from a different direction. What is the red dashed line?
That's the line that represents the demand up through the 1902 priority.
So what demand would be right above that line, that red dashed line?
1903 priority demand.
What demand would be at the very top for June of the dark shaded area?
That would be 1914.
What right priority is Byron Bethany?
1914.
Okay. And I want to do this because I think it's important to clarify what your cross-examination was on Monday. Earlier, a couple minutes ago, you added 2,252 to what I think you said was roughly 11,000 CFS for the June 7th plot point. The June 7th daily full natural flow.
Correct.
Which, just for clarification, that's the end of that blue line.
Clarify for the record which graph we are adding this to, what the name of the exhibit is?
WR
It's 50
48.
Go ahead.
This is 48.
Okay.
This is the one that was the subject of the cross-examination by Ms. Spalletta on Monday.
Yes, I think the prior exhibit you referenced was 52, so the record was confusing. So I just want the record to reflect that this testimony is relating to exhibit 48.
Thank you. Can you eyeball where the top of the dark orange chart is in CFS?
16,000.
Okay. So can you eyeball what the rough difference is in CFS between the red dashed line and the top of the burnt orange chart?
Somewhere over 2,000 CFS.
1,000 CFS. So that represents the what?
The amount of demand of 1903 and junior rights claims.
Up to
1914.
Okay. So if you were to reduce, and I believe you said roughly 16,000 for the top of the 1914, pre-14s, Ms. Spalletta asked you to subtract 740 from that. So just please use 16,000.
That would be 15,260.
Roughly 15,250, 15,260.
Sure.
I appreciate your engineer precision. What was please remind me, for the June 7th full natural flow point, I believe you said it was 11,000 plus 2252 CFS, which is what Ms. Spalletta asked.
Correct.
What is that?
That
If
was
you do that adjustment?
13,252.
Okay, so what is the rough difference between what you just calculated as the adjusted demand for 1914 and this adjusted supply for June 7th?
About 2,000 CFS.
1,000 CFS. Would you expect that the adjusted supply to reach a 1914 priority date?
No.
The adjustments that Ms. Spalletta asked you to make?
No.
And what is the last day of full natural flow on this chart?
June 7th.
7th. Okay, let's go please to WR-52. Now, can we zoom in again on June? And I'll say for Mr. Buckman, it's the column that has the straight horizontal line through it. Vertical, pardon me, a little flustered. And zoom in towards the top there. What is, Mr. Yazell, what does that purple vertical line represent?
That represents June 12th, the day the water unavailability notices were issued.
Okay, and then what do I want to draw your attention to the sloping dashed lines that are to the right of the vertical line. What do the big dots on those lines represent?
Those represent the
What
adjusted.
day?
Pardon me? Oh, June 15th. Those are the 15th. Those are plotted on the 15th of each month.
So for this chart, that big dot on either one of the slope lines that's just to the right of the vertical purple line is June 15th.
Correct.
Okay, I want to do very quickly because this was not done on Monday. Can we zoom in just a little bit more at the top part of this chart, Mr. Buckman? Thank you. And looking again at the June column, eyeball please roughly, what is the top of the demand represented by the dark orange?
Just over 15,000 CFS.
Over 15,000. And then there's been an adjustment, I believe you described already. I won't ask you to do that again, to the demand. Would that adjustment, as you understood Ms. Spoletta's questioning on Monday, the adjustment that you did on this chart incorporate the adjustment she asked you to do?
I can't confirm the exact number she used, but that did incorporate adjustments discussed by her, yes.
So this chart represents adjusted demand?
Yes.
So let's start with June 12th, and can you roughly eyeball where the dark blue daily full natural flow line is?
12,000 CFS.
12th, or is it?
Oh, I'm sorry, what date?
June 12th, where the horizontal line is.
Are you 12,000 CFS.
Right, where is it impacting the blue?
Ask me the question again.
For June 12th,
Yes.
where is the daily full natural flow amount in CFS?
Approximately about 12,000, just under 12,000.
Under 12,000, okay. And then where is the red dashed line? First of all, does the red dashed line mean the same thing here as it did on the previous chart?
Correct, yeah, that's
That is,
the demand through the 1902 priority.
can you eyeball where that is for June?
Somewhere between 1370-ish, 1375.
13 or?
13,750, I'm sorry.
Where the red line is.
Oh, I'm sorry, I'm looking at the wrong month.
Maybe Mr. Coates, if you could help.
Over
We're just reading this chart.
So it looks at the 1902 priority level for June. You're looking at extrapolating over to about 14,800 CFS.
14,800. And then where would the top of the 1914 priority be? Pre-14s?
I want to say about 15, a little bit less than 15,600.
So it's a different difference than on the last chart. What is the difference between the most junior pre-14 and then the most senior 1903 that we talked about last time was roughly 2,000 CFS? What is it here? And again, just eyeballing.
Trying to, one more time.
How far apart are the red dashed line and the top of the
red and the top. About
Looks to be about from 14,800 on the 1903, and then we're going up to about 15.6, so about 800 CFS.
Yeah, we can round it to 1,000.
Okay.
Okay, let's go back. So for June 12th, the daily full natural flow blue line is at what? I think you said 11,000?
I want to say about 11,000, maybe 400 or so.
Okay. If you add 2,222.
I'm hearing someone, Mr. O'Loughlin.
Tim O'Loughlin, San Joaquin Tributaries Authority. I normally don't do these in these proceedings because I understand the relaxed rules and how we're trying to get information out. But the leading questions are getting a little overmuch, and if you continue, I mean, I'd just soon have the prosecution testify rather than the witnesses, because the questions are all leading at this point, and the witnesses are supposed to be testifying, not the prosecution.
Your objection is noted, Mr. O'Laughlin.
I'll make every effort to ask open-ended questions. I apologize.
I appreciate that, but I am most interested in understanding this and understanding this as quickly and efficiently as possible. To the extent that leading questions are necessary to improve my understanding, I will allow that.
Much appreciated.
But I need you to move things along.
Understood. And we will. I think that
And actually, before you do, I actually have two questions. When you say the demand has been adjusted, what adjustments are you talking about?
Excuse me. The adjustments from, I guess, the adjustments from the between the two graphs, or all the adjustments in general? There's
All the adjustment in general,
in general. I reduced.
Yes. As explained in your testimony.
As explained in my testimony. Okay.
But I thought I heard Mr. Chariainen asked you whether it included the adjustment that Ms. Spalletta asked for in her cross. And your answer to that was?
Yes. Or the adjustment that was made was before in the June, the analysis associated with the June 12th notice, there were demands that were omitted, or not omitted, but there were.
You want me to answer that?
You answer it.
Okay, so basically on the previous graph on WR47, you notice how in June we had a top pre-14 demand at 16,000 CFS. You'll notice here that on WR48, or whatever this is, WR52, that you notice at the top of the pre-14 demand for the same month is now at about 15,200. Coincidentally, equal to about 800, or the 740 that she was referring to.
okay. I'm going to ask this as not leading as I can. What's the difference in CFS in the dark horizontal lines? We can speed this along if you just note that on the horizontal axis.
Yeah, that's what we just described. So it's a difference of 800 CFS.
Now, on the left-hand axis, the dark horizontal lines are how many CFS?
2,000.
So
increment, okay.
the little hashes in between, how far apart are they?
Those are 400 CFS a pop.
Oh, I'm sorry. What I would like you to do is, starting from June 12th and going to June 13th, you can eyeball, but add 2,252 CFS to each plot point for the daily full natural flow. And qualitatively, please, describe where you would expect that adjusted supply, I'll call that adjusted supply for this question, to be relative to the 1902 red hashed line.
They were both be below that.
Adjusted would be below. I'm
Below, yes.
just restating your answer, and I'll ask you to state it more clearly next time. So if you've testified earlier that the big dot is June 15th, so you know that that's about 2 days. The end of the violations period is what for Byron Bethany?
June 24th.
In using your eyeball, if you add 2,252 to any of the days between June 13th and June 24th, what is the qualitative result relative to the 1902 red dashed line?
It's all going to be below it.
And the red dashed line is itself, where is that relative to the 1914 priority, pre-14 priority?
That's the demand through 1902.
So 1914 is above.
Yes.
Now, I want to get back onto the main question, which is what is the best demand data you can put together today? And we had a long colloquy about the February 2015 information order. Today, it is March of 2015. What have you received from the February information order, February 2015 information order?
We have the entire year of 2015.
2015, so that includes May 1st through November 2nd.
Correct.
In your exhibits anywhere, have you submitted a database that includes the February 2015 information order actual diversion amounts?
Yes.
Qualify by saying, did everyone report?
There was, it was at least a 90% reporting rate.
Where is that database?
That is presented in my rebuttal testimony.
Okay, and do you have in your rebuttal testimony a graphic representation of that demand database?
Yes.
That graphic representation include the full natural flow?
Yes.
Pardon me if I clarify the question, the daily full natural flow?
Yes.
For that period?
Yes.
I'm sorry, while you're thinking, let me ask a question. Why was that information submitted in your rebuttal testimony and not your case in chief?
That was prepared in response to my rebuttal to comments received from other testimony from the defense.
And why was it
I have no answer for that.
response and not part of your
I was
case
not
in chief?
directed to.
I would, at this point, given that I think the motion for non-suit is still pending, like to make an offer of proof to put up that figure to talk about it and have the witness talk about it, because we might not get a chance to do rebuttal if the motion is granted.
Do I hear objections, Mr.
Yes.
Kelly?
Dan Kelly for Byron Bethany Irrigation District. I do object, and here's why. You asked for the best available evidence to show actual supply and actual demand during these periods for these two folks. They put on their case in chief, and they were supposed to put their best evidence forward in their case in chief, period. There's no exceptions to that requirement. The fact that they didn't do it is perhaps a little bit troubling, but as Ms. Spalletta, I think, or Ms. Zalesi said, Byron Bethany Irrigation District and the WSID Irrigation District are not required to put on a case in opposition to the prosecution team's case. That they're required to prove all the elements with sufficient evidence in their case in chief. And if we chose to rest today, none of their rebuttal testimony would be part of the record. And so for a motion for judgment or directed verdict at this point in the proceeding, I think that it wouldn't be proper to consider their rebuttal testimony, which they would not be entitled to present should we choose to not put on a case in chief in defense.
Mr. Laughlin.
Tim O'Laughlin, San Joaquin Tributaries Authority. I have a more fundamental due process problem with putting on the rebuttal testimony. The complaint or the cease and desist order and the administrative civil liabilities, when they are presented to both BBID and WSID irrigation districts, are supposed to set forth the factual basis and the legal arguments for why the ACL and the CDO is occurring. Now, think about this in a time sequence. Those are being issued last summer. We are now into the case in chief, and now at this point in time, what we're hearing from the prosecution team is forget the complaint we sent out early on, forget how you were preparing your case, forget all that. We're not going to tell you the basis for, the factual basis for why you were illegally diverting water until we put on our rebuttal case. Now, I'm not going to get into, I know the rules are relaxed here and everything, but think about any quasi-plenary action being brought against somebody. Have you ever, and I'll ask any attorney in this room, if they can cite me one case where a prosecutor has said in front of a judge, I'm going to present my case, I'm not going to present my case in chief. I'm not going to tell you why this guy is guilty until I present my rebuttal testimony. And you've never heard of it, and you never will. And so the WSID and BBID, and we pointed this out in our brief, have been denied fundamental due process rights. And not only that, as this continues on in this fashion, a fundamental right to a fair hearing in front of the state board. Thank you.
Others? Ms. Zalezi?
Yes, hearing officer, I agree with the statements that have already been said, but just to reiterate, this is 2 levels above what should be allowed. The enforcement actions that were sent out were very express. They stated that they were based upon the curtailment notice and the information that supported that notice as of that date. For BBID, that was the June 12th document that we were looking at. So what we've heard today is that, no, there's a little bit better information. And what Mr. Tariainen is saying now is, wait, in my rebuttal, there's even better information. But Ms. Moroka testified, and our enforcement actions state that they are based upon one document and one document only. And we can only go so far away from that document, and rebuttal testimony with better evidence should have been presented in a case in chief or not allowed at all at this point.
Any other comments? All right. I
have a
Mr. Terry
very
Ryan.
brief response. Regarding the evidence, the board makes a decision based on the evidence presented at the hearing, not the evidence that was developed at the time of the issuance of the order. There was a lengthy discovery process in this case that went both ways, and the prosecution developed additional information based on the ongoing collection of data for the violations period that was just described. And frankly, the other side got all of that 6 months ago or so, or close to that, 5 months. And the perception, I think, that I'm hearing described from the attorneys is that we're somehow locked in. Ms. Moroka, in her deposition, and this is really a closing brief argument, but she described the basis for the issuance of the complaint, not the basis for the issuance of an order, which is based on evidence that's developed, really up until the evidentiary submittal deadlines. And that's what we've done. This was there was a motion to dismiss or a motion to exclude all evidence after June 12th, which, was mind-boggling. So I think there's a kind of a fundamental misunderstanding of the hearing process here, and the development and the submittal of evidence, and then what the board would rule on. So, and that's what we're talking about.
All right, thank you, Mr. Terry. And Mr. Kelly?
Yeah, thank you. Dan Kelly for BBID. We're getting sidetracked, and I appreciate that we need to get through this, but I will say that, and to the extent that we need to brief this and provide this information, that when we actually conducted our discovery and depositions, I will tell you that these witnesses were unable, even at the time of the depositions, to tell us specifically which spreadsheets and which charts were used to support this enforcement action. It was incredibly frustrating and took a long time. And we
They asked
wrestled
for it
with
too early. We've had this argument.
Enough, one at a time, Mr. Kelly.
And we wrestled, and we didn't take these depositions, I think, until November. And so that was many, many, many months after the administrative civil liability complaint had issued, and we were up against tight deadlines and holidays. And so we did our best to get those those depositions done. These folks are expert witnesses. They've been offered at least as expert witnesses. And an expert witness is supposed to be prepared at the time of a deposition to testify with respect to the testimony that they expect to provide at trial. So we have a fundamental objection with the fact that none of these witnesses were able to testify with respect to any of this when we took their deposition.
Mr. Kelly, I read those depositions, and they informed you at the time that they were working on their testimony, so let's...
No, I understand, but I guess what I'm saying is, but they're supposed to be prepared, and they weren't. And rebuttal testimony now is the first time that we hear about any of this. They never updated that information and said, hey, we continued our work, and actually here's the facts that support what we're doing. It wasn't until after we submitted our direct testimony, after we paid our experts to analyze what was in the ACL, and then when we got rebuttal, now we're being told it's something different. I think that's what Mr. O'Loughlin is talking about as it being fundamentally unfair. When somebody files a complaint, they're supposed to plead the facts that support the complaint, and then they prosecute those facts. That's an element, that's fundamental fairness, that a defendant be entitled to understand exactly what they're being accused of and why. And we weren't provided that now until rebuttal.
Thank you.
I would just suggest that these evidentiary arguments, and I've said this a couple times in the last minute or so, these are closing brief issues of evidence to argue on closing, and we should probably leave them for there. I will say, though, that I would ask the council to point to any portion of the complaint that doesn't make factual allegations that are
We are not going to do a back and forth.
I have one final question regarding the demand data and the 2015 demand data, and it gets to testimony that Ms. Maroka has already made with respect to what is in our case in chief and why the case in chief itself supports the findings that we asked the board to make. In which case, I would recommend that the parties
let me understand
withdraw.
this. You are no longer pursuing redirect of your witnesses with respect to their rebuttal testimony.
I was asking them questioning on both their case in chief and rebuttal, but then when we were getting into the specifics about where is the most up-to-date demand and supply data relative to the entire unavailability period.
And that answer is in the record.
Yeah.
Your objections are in the record, which I will take notice of and consider very carefully. And now
then,
I will allow you to ask your remaining questions.
very quick. Ms. Maroka, prior to the submittal of the case in chief, did you review the February 2015 information order submittal data?
I reviewed it in a cursory fashion. I was curious to see how many respondents we had.
And did you look to see whether that demand data changed the demand?
I had discussions with Mr. Yeasel regarding that because he's my technical expert on the demand data. And I wanted to be advised as to whether his review indicated that there was any reason to be concerned about updating from 2014 demand data to 2015 demand data. And he indicated that there was not a large difference. Given the very poor flow conditions, it would not change any of our conclusions with respect to water availability.
Water availability
For purposes of the drought analysis.
Hold on,
How
Mr.
about with
Tarayan.
respect-
Hold on. Ms. Spaldera?
That was just a going around the rule way of having Ms. Maroka literally read a paragraph from page 3 of Mr. Yeasel's rebuttal testimony, which is Exhibit 211.
So noted, Ms. Spaldera.
I recall that this came out on cross-examination on Monday, but I may be wrong. With that, and with the risk of inviting further objection, if I continue, I'll rest on redirect.
Questions?
Yes, I'm sorry. I think I just heard Ms. Maroka testify as to what Mr. Yeasel told her. I was wondering if Mr. Yeasel might testify as to what he said with respect to 2015 actual demand.
I did take a look at it, and it was, there was a reduction, but it did not seem significant enough to change any decisions.
For purposes of the
Or for-
drought analysis.
Correct.
But not for purposes, you weren't at that time looking at a specific enforcement action? I mean, when you say drought analysis, you're making a distinction from these actions?
It would not have changed. It did not change. No, we weren't underdoing any drought enforcement actions at that time. So that was at the beginning of around the time when the notices were being issued.
So clarify, when was this?
You want me to answer that? Yeah. So when we received the informational orders starting in March, I recall providing an update in this room or one of the other rooms during one of the drought updates every 2 weeks, where we had compiled the projected 2015 demands that they were required to submit, and we compared that to the 2014 demands of those same parties. At that time, there was only a 4% difference to their benefit as far as a reduction in demand.
And when did you compare it to the actual 2015?
Well, those actual 2015s are ongoing, and that's when we actually incorporated that in the late summer.
Other questions? Mr. Buckman, I know you had specific questions. I would prefer you to hold your questions until after the recross. Okay? With that, let's take a short 5-minute break, and then we will resume with recross by Mr. Kelly.
Thank you.
Mr. Kelly, are you? We're missing one prosecution team witness. Ah. Before we go back on record, let me make a request. It's very important that all the parties involved have the opportunity to hear what's going on and to respond appropriately. So for the audience members, I would ask you to please not comment and not disrupt the parties who are participating in this effort.
Hearing Officer Dudek, I have one question about where we proceed from here, and Ms. Spalletta and I are going to kind of both have some questions for these witnesses. I believe that you had indicated prior to reconvening here that that all of the parties in support and opposed were going to get a chance to do this. So are we going to allow the people that support the prosecution team to do?
I am just going to go down the list of recross.
Okay, thank you. I just, and so I don't want to run into the problem I had Monday where a lot of folks came up and asked questions to kind of rehabilitate the witnesses, and we didn't get a chance because we didn't reserve time to come back up and get some clarification. So we'll make an offer of proof if we need to, but I just want you to note that was a problem that we kind of faced on Monday.
And I appreciate your problem, and we'll get to it, but I am not inclined to allow recross of recross.
Okay, all right, thank you. So with that, I'll turn it over to Ms. Spalletta to begin the recross.
Thank you. If we could have prosecution team's exhibit 48 up on the screen, please. Yep. Okay, so Mr. Yazell, during the examination, your counsel asked you to clarify what the supply was depicted on this graph for June 12th, I believe? Or was it June 7th? Do you remember which date?
I believe it was June 7th.
Okay, so let's go with June 7th. And my understanding of your testimony was that when you eyeballed the supply, and by supply you were talking about daily F&F, correct?
Correct.
When you eyeballed where the daily F&F was, you said it was around 11,000, right?
Correct.
And then your counsel asked you to add to that the 2,252 CFS representing the subbasin unimpaired flows and the return flows, correct?
Yes.
And then you said that that meant that the total supply was 13,252 CFS?
I believe it was around that, yes.
Okay, are you looking at some notes that you wrote during
I'm
your...
just looking at my numbers that I wrote down
Did you write those during your testimony or before your testimony?
as we were talking.
Okay, very
Just
good.
where I did the math.
Now, looking at the demand on this chart, I just want to be clear that the demand represented on this chart, WR48, does not represent the actual demand in 2015, correct?
This is correct.
I also want to be clear that the demand that's represented is for the entire watershed, correct?
Specify which watersheds?
Well, it says at the top, combined Sacramento-San Joaquin River Basin.
Correct.
So we talked a little bit yesterday about the fact that
in this combined global watershed analysis, you included all of the demand from all of the watersheds and subwatersheds, regardless of whether or not there was actually enough supply in any one of those watersheds or subwatersheds to meet the demand in that particular watershed or subwatershed, correct?
I put the demands in as directed by my supervisors.
Okay. So there were instances in this methodology where the demand reflected could not have physically been met with the supply in that watershed, correct?
But I'm not the qualified person to ask that. I would give that to Brian.
Brian?
Yes, that is true.
Mr. Coates, I should say. I'm sorry. Okay, so do you know how much additional demand is reflected that could not be met by the supply in the watershed?
I don't.
Did you undertake any analysis of that?
As we didn't separate the watersheds into subtributaries at this time, no.
Mr. Yazell? Mhm. Did you conduct the analysis of how much excess demand you were reflecting over and above available supply in each watershed or subbasin?
No, I was not directed to do that.
So I want to look at two other graphs that you entered into evidence, the prosecution team entered into evidence yesterday. Let's look at WR 54. Graph 54 actually represents a different geographic area, right? Graph 54 is just for the Sacramento Basin with proportional delta demand. Is that correct, Mr. Yazell?
Correct.
And that's actually a subset of the combined data, correct?
Yes.
And in this graph, you actually did depict what the 2015 actual demands were as reported under the information order with the green line.
That was a rough approximation. It did not take into account the priority of any pre-14 demand that was in there.
It didn't take into account the
priority of that was basically just the reduced amount overall.
So that's the overall demand that was reported for senior right holders?
Right. It wasn't adjusted by priority date.
Okay, so it should have included everything of riparians and pre-1914.
Right.
Okay, so then that total for the adjusted senior demand in June looks to me like it's between 6,500 and 6,700, something like that. What is it?
I can't see the numbers.
It looks to be about 6,800.
Is that Mr. Coates testifying?
Yes, it is.
And then you also put into evidence yesterday another graph showing.
Mr. O'Loughlin?
Hi, Tim O'Loughlin, San Joaquin Tributaries Authority. Yeah, you guessed it, Mr. Kelly. This goes to your statement that it'd be nice to see and hear everything, and thank you very much. Appreciate it.
You want me to see it or Mr. O'Loughlin to see it?
Sometimes Tim gets more angry.
Mr. O'Laughlin, you are welcome to move over there.
To clarify for the record, we are writing on a giant Post-it note some of the testimony. So we have put down supply in the combined watershed of 13,252, and we have written down demand in the Sacramento portion of that combined watershed of 6,800.
I have a question or an objection. I'm interested to know what the relevancy of this chart and this line of questioning is, because it doesn't appear to address any of the redirect nor specifically the question presented by the hearing officers at the beginning of this afternoon's proceeding.
Ms. Paletta?
The relevance goes to your examination of your witnesses regarding the best available supply and demand data in 2015 to use for purposes of this enforcement action.
Thank you. Please proceed. And I actually appreciate this, being a visual person.
I love giant Post-it notes too. Okay, so looking at Exhibit 54, or excuse me, we're going to look at the next one, Exhibit 58. Mr. Yazell, Exhibit 58 is the San Joaquin River portion of the combined watershed, correct?
Correct.
So between Exhibit 54 and Exhibit 58, we have the two subsets or components that make up the combined watershed, correct?
Correct.
So on Exhibit 58, you also depicted the actual 2015 all senior demand with the green line, correct?
With the same caveat as before, it's not prioritized.
Okay, so it includes all of the senior demand.
Right.
And in June, looking at this particular graph, it appears that that June senior demand is somewhere in the neighborhood of 5,300 CFS, correct?
Yeah, it looks about that, yes.
Mr. Yazell, is 6,800 plus 5,300 12,100 CFS?
Feel like a first grader, but yes.
Hey, and you didn't even need your spreadsheet, so very good. Okay, now, again, I want to ask the same question about both Exhibit 58 and 54, which is the one we looked at previously. All of the demand, the actual 2015 demand for all of the sub-basins and sub-watersheds in each of these geographic areas was included on these charts, even if the supply in those sub-basins was too low to support the demand, correct?
I put the data in as I was directed to, but yes.
So the answer is yes.
As far as I know, I don't know the specifics about the watersheds. I can't answer that.
So then these charts reflect demand that could not have been met by the supplies depicted and would have had to have been met from another source, correct?
That wasn't part of the scope of my analysis. I'm going to defer that to Mr. Coates.
Mr. Coates?
Repeat the question. I was reading the legend there.
The demand that is reflected on exhibits 54 and 58 reflects all of the demands in all of the sub-watersheds for the geographic area depicted on each exhibit.
I would have to look at the supporting spreadsheet information to answer that.
You don't know, as you sit here today, what demands are included?
It's not referenced in the legend. I don't know exactly what. I'd have to look at the actual information in the spreadsheet because we did make some additional pre-14 curtailments to select sub-watersheds in the summer for the San Joaquin. And so I would, just to be accurate, I would want to review the spreadsheet information.
Well, I believe you testified in your deposition that that was the case. Did you do research after your deposition that changed your mind?
I don't recall exactly which graph I referred to. It was 277 pages, but yeah. Looking on the legend there, it appears though, because it does have the full natural flow stations for all of those 6 FNFs for the San Joaquin, that it would include it.
So it would have included all the demand.
Yes, because it does reference the FNF stations there. Correct.
So to the extent that these graphs, 54 and 58, include actual 2015 demand that exceeded the flows from the particular watersheds included, that demand is overstated.
That's just the demand that was reported to us. We can't actually report whether or not it was satisfied or wasn't.
So it is including demand that you know could not have been satisfied by what you've represented as the full natural flow.
Correct.
Ms. Maroka, how many of the patents that were submitted in response to the information order request for riparian rights are there?
I don't know that number.
Is there more than 1,000?
Well, the informational order request went out to slightly over 1,000 parties. Depends. Some parties were claiming pre-1914 rights, so they'll submit different kinds of information than the parties claiming riparian right. Some claim both bases, and they'll have to submit both types of information. So it varies a lot.
How many of the submittals of the more than 1,000 have you personally reviewed?
Probably 5 to 25.
And of those that you've reviewed, do you know the range of the pre-1914 priority dates that are claimed?
I was fascinated by a lot of the history and documentation and the deed type issues that I was reading, so I tended to focus on that rather than the date per se. I was curious to see the delta issues and what they were, submitting on their basis of right.
As you sit here today, you actually do not have an understanding of what the date range for the claimed pre-1914 rights are in those submittals.
Well, that's why I had staff assist me. I had them put it all on spreadsheet for me to document for me what the claims were and the types of materials that we received from all parties. And I did review that spreadsheet, so I'd have a better understanding as to what we had received and how well parties had done on their submittals.
You expressed an expert opinion in your redirect examination regarding relative priority dates, but what I'm asking you is, as you sit here today, do you have an understanding of what those relative priority date ranges are?
I have an understanding of the materials that I received. That's over 1,000 parties. I couldn't say, which priority of one party versus another when you're looking at such a large volume.
And the dates in the database that you had your staff prepare, they were not actually used to sort the demand that's represented on the graphs that we've been looking at during this hearing, were they?
We used the materials that parties have submitted to us with their statements of water diversion and use.
You did not sort the demands that are depicted on the yellow, orange, and burnt orange sections of this graph by priority date for the purposes of depicting the demand.
Staff relied upon our eRIMS database to sort the dates and information from that database.
Ms. Maroka, I've now asked you, I believe, 7 questions that were yes or no questions, and you have not answered any of them yes or no.
Did you want a yes or no answer to that?
That would be nice.
Move on, Ms. Valera.
Okay. Ms. Maroka, do you remember in your deposition when I asked you what the source of information was for the 40% return flow for the Delta?
I don't recall. Perhaps you can refresh my memory.
I asked you, and I'll go to that page of your deposition. It's on page 35. My question was, were you part of the discussion regarding a decision to include the Delta return flows? Answer, I believe I was. Question, and can you tell me about that discussion and how the decision was made? Answer, yes. We have participated in multiple stakeholder outreach meetings throughout this year to make sure that we had the best available information for the water supply situation. And one of the comments that we received was with respect to the return flow. Parties felt that we should include some return flows in this discussion. We were able to identify a published document, a written document from another agency that informed us of what would be applicable return flows. Question, which document was that? Answer, I don't have the specific title off the tip of my tongue. Question, do you remember the date of the document? Answer, I believe it was a Department of Water Resources publication that talked to the issue. Question, do you remember whether it was recent or something that was published a long time ago? Answer, I am uncertain whether it was the 1977 drought report or whether it was another report. I think the 77 drought report might have been that source, but we were provided with another document at one of our outreach sessions that spoke to issues such as this, and I just don't recall its title offhand. Question, I found one in the Public Records Act request. That's the request that we made to the State Board that they provided documents in response to. That was dated July 1956, DWR Report Number 4, entitled, quote, Investigation of the Sacramento-San Joaquin Delta, Quantity and Quality of Water Supply to and Drained from the Delta Lowlands, end quote. Does that sound familiar? Answer, and it does sound familiar, and I believe that document was the one that was provided at outreach to us. Question, correct. Do you know, as you sit here today, whether the return flow information was taken from the July 1956 report or from the 1977 report? Answer, I believe the return flow information is only available in one of those two documents. I believe it is the document in your hand. Does that refresh your recollection?
Yes, it does.
I'm going to hand Ms. Maroka what has been marked as WSID Exhibit 183, which is available for Mr. Buckman to put on the screen. Ms. Maroka, I would like you to look at Exhibit 183 and confirm that this was the email transmission from Dante Nomalini Jr. dated May 12, 2015, following the stakeholder meeting and including as an attachment DWR's 1956 report number 4.
It is that email?
And this is the document that you testified in your deposition was the source of information that you used to compute the 40% delta return flow number that was then included in your analysis, correct?
I may have mentioned that, but I'm not certain that that's the case. I think it's the 1977 document which we used.
So at your deposition, you told me it was the 1956 document I had in my hand. Did you change your mind?
Neither Brian Coates nor I remember exactly which document. So it's one of the two.
Hearing officers, Andrew Tarianen, prosecution.
Mr. Tarianen?
I'm going to restate my objection regarding relevancy. This is going pretty far afield of any of the scope of redirect or the question that was presented at the beginning of this afternoon's proceedings. And it appears to just be additional cross-examination, particularly on issues that are raised in the other side's case in chief, which hasn't been presented yet.
Ms. Paletta?
I actually didn't think we were having to deal with this issue. I didn't think it was disputed. But then in Mr. Coates' redirect testimony, he specifically stated that the 40% number was something they had no support for and that they included it to be generous to the diverters.
You may continue, Ms. Paletta.
Thank you.
Good afternoon. I have a few questions, but first, Mr. Uzel, I want to ask you a question because I noted that a couple of times you testified about the inclusion or exclusion of data from the spreadsheets, and generally your response was preceded or began with kind of a qualification that you didn't decide what to include or exclude into the analysis, that those decisions were made by people other than you, and you simply did as you were directed to by supervisors or folks above you. Is that an accurate statement?
Correct. I compiled the data and created the graphs based on the parameters set by my supervisors.
So you made no decisions with respect to what would be part of the best supply data set or what would be the best demand data set, correct?
Correct. I was told what they were, and I went and collected the data.
Mr. Coates, did you make any decisions on what would be included in the supply data set?
No, that was done by my upper management as a continuation from the 2014 route.
Mr. Coates, did you make any decisions on what would be included or excluded in the demand data set?
No.
Ms. Moroka, other than the 40% delta return flow issue that you just spoke to Ms. Spalletta about, did you make any decisions on what would be included in the supply demand data set for this, in the supply data set for this analysis?
I was a participant in conversations with John O'Hagan. It was a continuation of 2014 where Mr. O'Hagan informed me that...
I want to interrupt. I'm not asking about what Mr. O'Hagan did. I want to know if you made any decisions on what would be included in the supply data set for this analysis. Did you make any of those decisions?
It was a continuation of the 2014, which was before my time.
Did you make any of the decisions on what would be included in the supply data set for the 2014 analysis then?
That was prior to my assuming my duties.
And so is that answer no?
Correct.
And so the same would be true for 2015. It would be no.
No, in 2015, I had to look at, I guess, no, that's demand. Never mind, yes.
And so for the demand side, Ms. Moroka, did you make any decisions on what would be included or excluded in the demand data set?
Absolutely.
And what decisions did you make?
I looked at the issue as to whether we should include the informational order demands in the data set.
And so is your contribution then to the demand side the utilization of information from the 2015 informational order, which was the 2014 actual demand?
Yes.
Other than that, did you make any decisions on what to include or exclude from the demand analysis?
Absolutely.
What other decisions did you make?
I made a decision with respect to the month-to-month incoming 2015 data and whether that would make a change in our numbers, and should we update every single month as it goes for the 2015 incoming data.
But are we still talking about the 2014 actual demands?
2015 incoming demand data from the informational order, the month-to-month data we got in.
Okay, so we heard a little bit of testimony on recross about incorporating that data as it rolled in, and so is your testimony then that another decision you made with respect to demand was to include in the rolling analysis the actual 2015 demands that came in?
No, after I had my conversation with Mr. Yazel, it didn't appear that we would need to do ongoing month-to-month updates on the 2015. We did do updates. You've seen those graphs today. But we were looking, that was my decision-making as to whether we had to keep rolling and changing every single month.
And so it was your decision to not do that?
It did not affect the information on water availability because the supply was so low. And so it was my decision that we would go ahead, and we did do the recast backwards that you've seen in our exhibits today.
Ms. Roca, I'm simply asking whether or not it was your decision then to exclude that additional demand data from the analysis.
For a brief period of time.
Is that a yes?
Yes.
So if I was going to ask someone, any three of you, whether specific supply sources would be useful in an analysis of water availability to the Byron Bethany Irrigation District at its diversion facility in the South Delta, who would I ask of the three of you? Would it be Mr. Coates?
Exactly what type of question are you asking?
Well, I'm going to identify some different sources of potential supply that might be available to the Byron Bethany Irrigation District.
Okay.
And I just want to know whether or not that kind of information would be useful in conducting an analysis of the supplies actually available to BBID.
Okay.
So,
Instead of useful, I would prefer you ask the question in terms of whether it was actually considered.
okay, I will ask if this was actually considered. Mr. Coates, first of all, you did not conduct a water supply availability analysis at or near Byron Bethany Irrigation District's point of diversion. Is that correct?
I only conducted a comparison, not a full-scale, full natural flow availability, correct.
And this is the watershed-wide analysis we've been looking at.
The comparison that I referred to was the area downstream of Vernalis, which included both PODs along with everyone else in the Delta.
And you didn't look at any other source contribution other than full natural flow, is that correct?
In that particular Vernalis comparison, I only used, since it wasn't a water availability determination, we used the actual mean daily flow at Vernalis, which was we referred to as a comparison.
But you didn't use that for the water availability analysis as part of this enforcement proceeding, did you?
We actually prepared that after we had issued the enforcement actions as a check.
But it's not part of the evidence supporting the action against BBID, is it?
It's a rebuttal exhibit.
Did you consider the contribution of any wastewater treatment plants in or around the Delta as a potential source of supply for BBID?
Those types of waters were brought to my, I think to John Hagan's attention, and we discussed that, and it was elected at that point. Either he or someone above him made the decision to only use full natural flows, so we didn't include those.
So do you know whether or not that information is reasonably available?
As far as documented?
Yes.
I have no knowledge of that because it's not on my email.
So one of the things that caught my eye in the administrative civil liability complaint and kind of what's been talked about here is how easy it was to find out that BBID was what you all thought was unlawfully diverting because BBID reported its diversions and they showed up on CDEC. Is that correct?
Correct.
And so are you aware that the Sacramento County Regional Sanitation District also reports its wastewater discharges in the Delta and that information is also reported on CDEC?
That's not information that I usually seek out, but if you say so.
So you didn't include that in the supply?
I did not include that in the supply, no.
And so if in the month of June, the supply that's shown on these charts, if SAC Regional discharged at an average rate of 160 CFS for the month of June, that supply component would not be depicted on the graphs that you showed.
If it was considered full natural flow, it was included, but as I indicated earlier, if it's not full natural flow, we didn't include it.
Can you tell me whether or not you know it's full natural flow?
I can't speak to that now.
Do you have any idea in acre feet over a month 160 CFS is in the month of June?
160 CFS on a daily basis is going to be about double that in acre feet, so 320. So you're looking at about a little under 10,000 for a month.
And do you have, do you recall the amount of water that BBID is alleged to have unlawfully diverted in the month of June?
I believe it's 1,880 something acre feet.
So less than 20% of the total quantity of water discharged by SAC Regional?
Using that comparison, yes.
And if you know, is water that would be discharged from a wastewater treatment plant available to riparian diverters?
That's since it's that's usually available for appropriation.
So it would be available to a pre-1914 appropriator?
It will really depend on the source of water in the treatment plant. I have seen treatment plants with short residence times where the water retained its riparian character. So it's going to depend solely on source and resident times and other factors.
But you don't know what the source of water is that resulted in those discharges at Sac Regional, do you?
We've made no evaluation of that.
If I excluded the Central Valley Project and the State Water Project, did you include the return flows from releases from other storage reservoirs?
Now, the only return flows that we added were the percentage of the supply along with the 40% delta flow.
And so is the answer to that no?
As far as I know, no.
Are you aware of recent documentation that came from the Delta Office of Delta Water Master with respect to the success of the voluntary reduction program in the Delta in the summer of 2015?
Objection, hearing officers. Robin McGinnis for DWR.
Ms. McGinnis?
I thought the scope of this redirect and recross was the quality of the data the prosecution team used, not other sources of supply they should have considered in their analysis. I thought those issues were part of the moving parties' cases in chief.
Kelly?
The hearing officer, my understanding of what we were doing today was trying to determine whether or not the evidence that the prosecution team used is the best evidence to make that determination. And I am asking about other sources of supply that would have been available to BBID and WSID to find out whether or not those sources were included. We have a supply line on the graphs. I want to understand whether or not that supply line includes any of these other supplies.
I will grant it, but I also ask you to move along. I think you're making your point.
Hearing
I will.
officers, all of the,
Yes?
what is included in the prosecution team's supply and demand analysis is it's detailed extensively in their case in chief written testimony. I'm not sure we need to go over this today.
Thank you, Ms. McGinnis. I'll take your objection into consideration, and I will ask Mr. Kelly to move along.
Are you aware of the reported savings from that voluntary reduction program?
We are aware of that, and the issue on that program is it compares the water savings in 2015 to a 2013 baseline year, and we are not looking
I think the
at
point
that.
here, Mr. Kelly, that you're trying to make is that it was not considered. So let's move on.
Okay, thank you. Can we look at WR 47? Actually, I'm sorry, 48. My apologies. I believe, Mr. Koster, Mr. Uzel, which of you testified with respect to adding the 2200 CFS to the supply line? I believe it was on this graph, and I don't recall which one of you testified to it. That was Mr. Uzel.
That was
Mr.
me,
Uzel,
yes.
just a quick question for you then on that. This graph shows the combined Sacramento-San Joaquin River Basin senior supply, so the entire watershed, correct?
Yes.
And the return, and so the demand that's depicted on here is the demand in the entire watershed, correct?
I believe so.
Well, I'm looking, and I'm
I'm
sorry, I
trying to-
didn't actually mean that to be controversial. The chart, I just assumed because the chart says 2015 combined Sacramento-San Joaquin River Basin senior supply demand, that it included that demand in the entire watershed.
I'm-
And I believe that you testified yes.
I think I did, yes.
And so the return flow component that we're talking about adding, what is the source of that return flow component, that 2200 CFS?
That would be For June, I believe it was a 10% return flow for the San Joaquin area riparian demands.
Was it solely out of the San Joaquin River?
It was applied globally to the entire area.
And that was a return flow component from the prior use of water? If you know?
I don't know the source. I know it's a 10%. It was
Yeah,
10.
It's actually referenced in the legend there at the very top on the right. It's got it by month. Looks to be for the month of June, 10%, and then it also references a delta contribution of 40%.
Okay, so then my question is, and this is similar to the question that Ms. Spalletta asked about demand, unmet demand from some watersheds being carried over into other watersheds. Is it true, based on the work that you did, that the return flow contribution to the supply couldn't be accessed physically by a lot of the demand depicted in that chart?
If the 40% component of that 2,250 CFS, if that's a large component of it, then since that's localized to the delta, that extra supply would only be available to the delta if it was localized, correct?
But here it's shown as being charged by the watershed-wide demand.
Correct.
Okay. So as an engineer, and I believe all three of you are engineers, do you think that that it would be helpful in conducting an analysis of actual supply and demand to try to remove the demands that couldn't be accessed by the supply, so you get a more accurate picture of the actual supply and demand?
Of course.
I have no further questions.
Other members of your party? Ms. Alesi, no question? Okay. Let me ask the third witness, it's been almost an hour. Would you like to take a break or continue? Go forward? All right. Let me ask the City and County of San Francisco. Actually, they're not here today.
Yes, they are.
Oh, they are? They came in late. All right. Do you have recross?
Thank you, Jonathan Knapp for the City and County of San Francisco. We have no recross, but we would like to note that we support the motion that's been made.
Thank you. Mr. O'Loughlin, do you have recross?
Yes, I do.
Ms. Duduck, one moment, please. Could you please ask Ms. Spalletta to put a exhibit number on that big Post-it and take a picture of it and send us a PDF file of it, please?
Thank you, Mr. Mona. And then Mr. O'Loughlin can actually see it.
I put on my glasses. Can you put Exhibit 58 up again, please, the San Joaquin River Basin? Thank you. My questions are directed to any of the three of you who wish to respond. And I'm trying to get at what is the best available factual data you could have available when you were making your determinations. So I want to focus on the San Joaquin River Exchange Contractors. Are you familiar with the San Joaquin River Exchange Contractors?
Somewhat, yes.
So if I look at this chart that's solely based on the San Joaquin River Basin, is the San Joaquin River Exchange Contractor demand depicted in June of 2015?
As I explained to Mr. Kelly earlier, since the legend references the full natural flow station at Millerton, it would.
So do you know, as you sit here today, or can you access, looking at this demand chart in June, my understanding would be is that there would be a number associated with the demand for the San Joaquin River Exchange Contractors. Could you tell us what that is?
I can't tell the exact demand, but it's in the spreadsheet.
Can you look at a spreadsheet, Mr. Yezel, and tell us what the demand for the San Joaquin River Exchange Contractors would be in June of 2015?
It would take a while to pull that out, but it is possible.
Could we, and I ask your indulgence, I normally don't want to delay things. Maybe the break that you were looking for, we could take a 5-minute break and Mr. Uzel could look that up because the number is important to understand the graph and what occurred with the demand side on the San Joaquin River Basin. Is that okay?
Let's go ahead and take that 5 minutes. Thank you.
Thank you.
Will you please take your seats? All right, Mr. Laughlin, please resume your recross.
Thank you very much. Did you have an opportunity to ascertain the 4 exchange contractor member units demand on chart 58? Can you put 58 back up on the screen, please? Up.
Lost Mr. Buckman, who has to take the long way around.
They're looking for 50.
Right, there's no.
$58, please. Thank you. Okay. Do you have an answer for us?
So for June, the exchange contractors' demands, and these are reported in their 2014 demands from their information order, came out to 92,753 acre feet.
Equates to how much in CFS? About 1,500?
About 1,500 or so.
Now, on this demand chart then, if the exchange contractor's demand is depicted, and you included it all as riparian demand, is that correct?
Yes.
Okay. And they would be taking 1,500 CFS off the San Joaquin River to meet their demand in June of 2015, correct? Based on this chart.
Yes.
So I'm going to try to reconcile something here. I called up my friend Steve Chedester yesterday, and I asked him when they got their water. And he responded, the release quantities we received from Millerton Lake.
Mr. O'Laughlin, who is this you're referring to, and why are you introducing his
I'm
testimony?
not introducing, I'm just asking a question. You'll see, just bear with me for 2 seconds.
So ask your question, please.
No, the question includes a quote, and I want to know if he agrees with this or not. So this is from Mr. Steve.
All right, Mr.
Prosecution team objects to the hearsay that's being attempted to be introduced.
Well, yeah, but this whole hearing.
All right. I'll take it under advisement.
Thank you. It's a real simple question. So Mr. Chedester denoted to me in an email.
Actually, you don't have to go on that. Just read the statement and ask him if he concurs.
Right. That's what I'm going to do.
Just read it, yes.
Well, I just wanted to make sure because it didn't seem like they understood who it was from. The release quantities we received from Millerton Lake did not begin until mid-July. So how is it that this chart depicts a supply and a demand to the San Joaquin River exchange contractors in June that they never used from the San Joaquin River?
Mr. Karianen, were you about to object? I saw you reaching for your microphone.
Again, there's hearsay. I restate that objection. Sounds like he's testifying as to the contents of a document that he could submit if he wants to submit as evidence. So that's the secondary evidence rule. And also, I think he's assuming a fact that's just not an evidence that's stated in this purported email. And it's irrelevant.
Well, Mr. Laughlin, unless you can restate, I will ask you to move on.
Oh, no, I'll state it another way. Did any of you call the San Joaquin River exchange contractors in June of 2015 and ascertain if, in fact, they were diverting water from the San Joaquin River basin, the San Joaquin River in the amount of 1,500 CFS?
What we received from the San Joaquin River exchange contractors was a letter telling us their diversions under riparian right.
One other thing I wanted to get cleared up based on the best evidence, and we talked about this a little bit, and so we'll try to focus in on this on exhibit, I think it's 47, which is the chart that has all the demand in it. Or is it 48? I forget which one it is. Might be 47. Oh, there we go. No, make it it's the Sacramento San Joaquin Bay Delta one. It's the next. Oh, there we go. Thank you very much. And anyone can answer this question. So if I was looking at this chart, I'm still trying to figure it out from your testimony on Monday and then your recross from today, how would this chart change if you had not changed the pre-14 riparians to all riparians? Or let me ask it a different way. Would the riparian demand that's depicted in June under this chart be decreased if you had not changed all pre-14, people who reported pre-14 riparian rights to all riparians for June of 2015?
Yes, it would be different.
And would the total demand number thus come down for the chart?
No, the total statement demand would be the same.
But the ability for other pre-14 and appropriators, depending on where they are in the pecking order, they may be entitled to take water, correct?
If an amount was reduced under the riparian block, then if the statement demand being the same value, of course, the pre-14 amount would expand.
This will sound like a really silly question, but bear with me. I'm looking at these charts and graphs, and we've been talking in hundreds of CFS and thousands of CFS. Can you tell me, based on the thickness of these lines, what the margin of error is by the line itself?
No, we don't actually have the, the reason we have the thickness of the lines drawn as is for aesthetic purposes. Otherwise, it's very hard to read.
Yes, our actual work is based on our spreadsheets. It's numeric.
Thank you. I have no further questions.
Thank you, Mr. O'Laughlin, Department of Water Resources.
Questions, thank you.
State water contractors.
We don't have anything as well. Thank you.
Westlands.
Nothing further.
Sorry? Westlands.
Bill Williams with Westlands, nothing further. Thank you.
All right. Oh, did you want to ask your questions now or after they do their 5 minutes?
Probably now.
Okay, go ahead.
Great. Could you put up exhibit WR52? Mr. Coates, earlier today you mentioned that the daily full natural flow information shown on water right WR52 was the best supply data that you had available. Is that correct?
That's the best supply information looking hindsight, but as we're actually putting out notices, we don't have the forward-looking daily FNF. We only have the monthly FNF forecasts. So the best information we have, as Ms. Dodek indicated, as of today, is the daily FNF because we know that data. At the time the notices are issued, we don't know what the flow is going to be, and we can't project daily FNF. That's why we use the monthly forecasts.
Where in your exhibits does this data reside? For the and when I mean data, I mean the daily full natural flow.
That would be in the spreadsheets that Jeff Uzel can answer to.
It's WR70 something. I don't have the number directly.
So the full natural flow data that's shown as blue in WR52 is located in an exhibit 70 something.
Yeah, the master supply data is in. I compile it in one Excel workbook.
If we put up the list of exhibits.
Yeah, if you pull up the list, I can.
Michael, if you try 72, let's see if that's familiar.
Yeah, that's it.
And Mr. Uzel, so which data is referred to as the daily full natural flow data, just so it can be clear?
Yeah, I have it split up between the Sacramento stations and the San Joaquin stations. You can see there the two tabs on the left. One, so I have the CDEC daily FNF dash
SAC and CDEC daily FNF dash SJ. So so we're looking at the tail end of the data. So the left columns, the far left columns are the actual data from the CDEC websites.
And so what column would we use for the total?
The total for which, refresh my memory, we were looking at 50, the graph we were looking at.
52,
Net.
WR 52.
And that comprises which, I don't have all this. Okay, that's Sacramento, San Joaquin. Okay. So we go back to, that would be the SJ6 plus SAC4 column. Yeah, right where your mouse is.
Okay, thank you.
You're welcome.
Mr. Buckman?
Quick question for you, Mr. Giselle. Is there any reason why this data in this chart, in this particular cell, column, would be different from the data in a previous spreadsheet, say in WR77? It shouldn't be. Actually, that's where I keep the data, and whenever I make a new analysis, I just copy the daily FNF for the appropriate watersheds over into the analysis spreadsheets, so they should be the same. So looking at June 7th, it looks like the total would be 11,292. Is that correct? Correct. So looking at WR77 on June 7th, it looks like the total monthly FNF you have here is 11,337. Oh, the daily, sorry, it's the daily FNF is 11,337, which is slightly different. So could you explain what the discrepancy is? That could be when, there was possibly, there's depends on the date when I pull the data. Once I create a graph, I may have created it so close to that period where the numbers may have been adjusted a little bit. So the most accurate data would be where you just showed us previously. Correct, but I tried to timestamp the data we had at the time that I created that particular spreadsheet. So it was current at that time. As I mentioned many times that these are living documents, and they supplies and demands do change slightly over time. Can you point out the timestamp where that's located? I wasn't being that literal, but so if I usually go by the time it was saved, or as far as the file was saved, or the demand is based on whatever the date the RUD's spreadsheet is.
If I might offer just a suggestion,
Mr.
the witness
Tarian.
has, sorry, Andrew Tarian, Office of Enforcement. The witness has a copy of his case in chief, phase 1 testimony in front of him, and that document might allow him to refresh his memory as to the date stamp of this particular exhibit, which is WR77.
So WR77 was June 10th. Or June 10th.
Anything else, Mr. Buckman?
One last question, and I'm pretty sure you went over this, and I just want to be absolutely clear. For the daily full natural flow calculations, did you make any alterations or add any additional flows to those numbers? The only alterations I did to daily full natural flow were when occasionally they were reported negative in CDEC,
if they were reported negative, I converted those to 0. And that actually benefits that increases the flow, but it's kind of impossible to have a negative FNF.
So no,
Other than that, we saw that a lot during the summer months, but as far as any like other additions from other sources, no changes.
thank you.
Any other questions? All right. Not per party. Mr. Kelly et al., who is your wrap-up speaker? 5 minutes in favor of the motion.
Thank you, Hearing Officer Doduk and Spivey Weber and hearing team. I'm kind of taken back now to my opening statement and the frustration that I expressed in my opening statement. And I felt like we've been banging on the table and banging on the door for 8 months now to understand and have input and be able to get people to recognize the source of supply that's available to some of these folks so they can divert in the worst drought ever, or one of the worst droughts ever and the worst water supply situations ever, when there was what we thought was water available at our point of diversion. And so the folks that were here Monday and were here this morning were fighting for their lives this year. And in doing that, if we're gonna look to punish them for doing that, I think we better take a really hard and close look at the evidence that we're using to hang them out to dry, because that's what this proceeding would do. It would hang them out to dry. And what you've heard was that the best evidence that the prosecution team relied on was full natural flow. And full natural flow consists of, as Mr. Nemeth explained, computed figures up in the Sierras at rim stations that don't include downstream contributions to the supply, and there's no adjustments made, and it's just this kind of theoretical number. And then we have the dailies that don't include return flows, that don't include discharges, that don't include return flows from groundwater use. None of that actual real water shows up in full natural flow numbers. It's not in dispute. It's not in dispute. You also heard no evidence about the source of supply that these folks have accessed for 100 years, and that's the water that remained in the Delta. And that was one of the things that the hearing officer said that they were kind of interested in learning about in this proceeding through the case in chief. And not only did you hear no evidence about what quantity would be contributed by that source of supply, you actually heard no evidence with respect to why it was excluded. And so you should be asking yourself that. If this is really about the best evidence that was presented in the case in chief to determine whether there was sufficient water, sufficient real water, not theoretical, not paper water, real water available for the Byron-Bethany Irrigation District and for West Side, you have to look at all of those supplies. BBID is accused of taking 1,800 CFS at a time in June when the full natural flow says that water wasn't available. Mr. Coates just testified that the Sac Regional facility, which discharges into the Delta, contributed 10,000 acre-feet of water into the Delta. BBID is only accused of taking 20% of that flow, which isn't available to anybody else. It's not available to riparians. I'm reminded it was 1,800 acre-feet that BBID is accused of taking. But those are the sources of supply. If you're going to try to punish these people, and if you're going to try to cut off their ag supplies for an entire summer when they've got crops in the ground, when there are truck crops in the ground that need 1 or 2 more irrigation cycles to get them out, you better make sure it's right. You owe it to them. The Division of Water Rights owes it to them. Now, maybe the full natural flow concept is great, like I said, for a planning level, and you look at these big watershed-wide issues. But if you're going to kind of drill down and accuse people of stealing water, I think that we really need to make sure that we've considered the entirety of the source of supply, that we've considered the appropriate demands on that supply. You heard Mr. Coates testify that in his opinion, as an engineer, he would have removed all the data that couldn't be met from subwatersheds where the supply was insufficient. But it wasn't done. Now, I don't fault Mr. Coates, Mr. Yazell, or Ms. Moroka for that because they didn't make the decisions. But somebody made the decisions, and it was excluded. And so supply was omitted, demand was overstated, and it painted a picture that you see in those graphs that wasn't real. It wasn't real. And we know it wasn't real because, like we looked at the one chart in March and April, when supplies were only 10% of the demand for post-14 rights and everybody was diverting to storage, how can that possibly be? It can possibly be because the data that we looked at, while it might be useful for some purposes, appears to not be as useful for the purpose to which it was put for this proceeding. And so there's no dispute that a lot of the supply was excluded, the demand was overstated, and if that's the best evidence, it can't be sufficient enough to impose the fines and issue a cease and desist order in this case. Thank you.
Mr. Terry, your 5 minutes.
Thank you, hearing officers and members of the hearing team. The issue that's before you now is this motion for non-suit. What I just heard was 5 minutes of argument that is really their case in chief, which has not yet been presented. If any of that is interesting and worthy of further exploration, we should allow their case in chief to proceed. But I want to talk about what the motion is, the non-suit standard. There is no standard that applies in this proceeding for a non-suit. The two sides have suggested that portions of the Code of Civil Procedure might be informative here. And where are we here in this proceeding? We've had the case in chief evidence from the prosecution. We haven't had the prosecution's full phase 1 evidence yet. We haven't had the rebuttal. We haven't had any of the other evidence by any of the other parties submitted. The standard that is best applied here is the 581C standard, which is a deferential standard to the plaintiff. Code of Civil Procedure 581C. That's what when I said that all the indulgences need to be made in favor of the prosecution team and all the conflicting evidence should be ignored. I want to also talk about the standard of the evidence here, which was raised in the opening arguments at the beginning of the morning. This has been brief, but I just want to simply state the standard here is the preponderance of the evidence. We've talked about what that was. I mentioned it in the opening. I've briefed it. There is no authority that holds otherwise in this type of proceeding. It does not involve revocation of a vested right or anything like that. It's simply an enforcement action as to whether or not a party or two parties took or threatened to take water in excess of their rights. This discussion about the best evidence is interesting and somewhat perplexing because it's not an actual standard that applies to these proceedings or really any other. In legal parlance, the best evidence is a rule regarding admissibility of certain types of evidence and maybe excluding certain types of evidence. I think the term best evidence here has been appropriated from some opinion that Ms. Moroka gave in her case in chief testimony where she said, I believe I'm going to probably misparaphrase even, but that the supply and demand data used to support the May 1st and June 12th notices was the best evidence available. And that is now attempting to be imputed into a standard of evidence that the prosecution team needs to meet. But the standard really is the preponderance of the evidence, and that asks whether the evidence submitted is more likely than not to support the facts that we're asserting. The same standard applies to the parties who are going to be submitting evidence in their case in chief. I want to talk about the cases in chief because we haven't seen the other side's case in chief yet we spent almost all this afternoon or a significant portion of this afternoon having these three witnesses being cross-examined on issues raised in the other side's case in chief. Those issues that are raised in the other side's case in chief are addressed in the prosecution team's rebuttal. that essentially muddies the record, especially with respect to this motion that's pending right now. And it's fundamentally unfair that the prosecution really couldn't present any of the rebuttal testimony that really is at issue and rebuts the assertions that were addressed in the cross-examination. Finally, the cross-exam that the Delta parties did regarding their own case in chief and the rebuttal testimony is irrelevant for the purposes of this motion, which really looks at the evidence that was submitted by the prosecution in its case in chief. And it's certainly premature. But again, if you think that any of the arguments that you just heard from Mr. Kelly or any of the issues that were raised in the redirect or recross examination from the Delta parties is interesting and potentially relevant to the issues in this proceeding, then allow phase one to continue. Hear their case in chief and then hear both parties rebuttal. The prosecution team asks you to please deny this motion for a non-suit. Thank you.
Thank you, Mr. Tariainen. Now that I've actually managed to learn how to say your name. Right. Couple of quick questions. Mr. Kelly, were you, or Mr. Kelly and Mr. Tariainen, were you able to work out the conflict with respect to, or the Department of Water Resources, with respect to Dr. Paulson and Dr. Hutton? And before you answer, I need to remind you that we did ask, these dates were known in advance. We did ask for any heads up in terms of conflict. I'm told we did not receive any notification of conflicts. I'm a bit perturbed that now your witnesses are not available. But in any case, have you been able to resolve that?
We have not had time to resolve that, and we have not.
Okay. All right, let's do this. Let me just say again that I appreciate everyone for going with the flow. I know we threw a curve today and we redirected and changed what was supposed to happen, but I think it was important for us, and we appreciate all the efforts that everyone put into today. We're going to take everything under advisement. I am suspending the hearing until Monday, unless you hear otherwise in terms of an official ruling from us. Be prepared Monday to continue with the hearing, starting with BBID's case in chief. I'm sorry, BBID WSID et al. Case in chief, as you outlined and proposed it earlier this morning. Was it only this morning? Earlier this morning.
I will, Dan Kelly again, I will, and I've actually already conveyed to both Mr. Tariainen and Ms. Ainsley, and I'll convey to the others that in order to try to make this go a little more orderly, we kind of hit that stumbling block yesterday morning. I'm actually going to email them with our proposal with the panels so we can let everybody try to plan and schedule appropriately.
That would be great. And may I also ask your indulgence for the transcript for today? Please.
If I may, and I apparently ran afoul of the prohibition on me distributing the transcript like I did yesterday. And so the hearing team knows, and so everybody in the room knows, Kathy Davis, who has been sitting here and getting us those transcripts so timely, was actually hired by my firm and by the Delta parties to enable us to have daily transcripts of the proceedings so we could refer to them. Ms. Davis is not here on behalf of the board or the Attorney General's office or anyone else, and so we are paying for Mrs. Davis's time and transcripts. And so if anybody wants transcripts, a separate arrangement is going to have to be made with Ms. Davis to be able to get a copy of those transcripts. And I'll email everybody about getting a sharing arrangement for her daily fees if people want to participate in that. But I'm happy to make that offer to split costs so long as everyone makes their own arrangements to obtain copies of those dailies from Kathy Davis.
Thank you, Mr. Kelly. Yes, Ms. Ainsley.
Yes, I had maybe misunderstood Mr. Kelly this morning. So you're saying you're suspending the hearing till this coming Monday?
Yes.
Because Mr. Hutton is in Indiana taking care of some personal family matters next week, so we do anticipate having quite a problem with next week. I know that Mr. Kelly and I had talked earlier about the subsequent Monday, so I think I was maybe not listening as well.
Again, we'll ask the two of you to work it out, and if Dr. Hutton's presence is necessary for Dr. Polson's testimony, is there any way, Mr. Kelly, that your witnesses could be taken out of order?
I could certainly attempt to accommodate that. I don't know Dr. Hutton's availability. I understand that he's not available this Friday or all of next week, and I'd have to check with Dr. Polson on her availability. While I appreciate the admonition that the chair gave, when we are trying to, it's very expensive to have consultants, as you all know, and we've been paying our consultants to be here every day this week in anticipation of getting them on, and I've not asked them to be available every day for the entire 2-week period because I think we all expected to be through phase 1 by the end of this week. So I do apologize for the conflict that it's caused, but I hope that it's at least somewhat understandable given what's happened in the proceedings. I'll work with Ms. Ainsley and see if there's a day in common. I'm going to have the same problem. I need Dr. Paulson here when Mr. Hutton provides his rebuttal too, and so.
I will leave the two of you to work it out and submit something to us as part of your proposal.
Thank you.
Ms. Ainsley.
Thank you very much for that, and I would like to offer as well right now that we do know that Mr. Hutton is available the following week, that he will be back from his Monday morning.
Thank you. And Mr. Morat, I saw your hand, and I can anticipate now. We promised you Friday, if I recall correctly.
Correct. I have plans to be out of town next week.
Are you available the week after?
Perhaps not until the 9th or after that Friday.
All right.
Heard today.
Sorry?
My written testimony only exhibit is 815 words. I could be heard today.
Comments from parties?
Yeah, Dan Kelly for BBID. I do appreciate the difficulty. I'm not ready to cross-examine Mr. Morat today. The earliest I anticipated him being on the stand was Friday, and so I'm not prepared for that cross-examination.
All right. Mr. Morat, my apologies to you because of the changes in proceedings. We will have to revisit with you, just as we are extending Mr. Kelly and Ms. Ainsley the opportunity to try to resolve scheduling conflict. We will do the same with you, but we will not be taking your testimony either today or Friday.
Okay.
We'll try to find another time should this proceeding continue the week after next week while you might be available. Mr. Williams.
Thank you. Phil Williams with Westlands. Just in an effort to be helpful, what began a lot of this was yesterday morning, an attempt to understand the timing requirements that would be imposed on the parties as they present their case in chief, whether it's panels and how long each person gets, but that also implicates the cross-examination time, and I'm not really sure that that's been resolved, so I don't want us to lose sight of that pending and perpetuating problem. Thank you.
Hang on, Mr. Tariainen had been waiting, I believe, to make a comment. Microphone.
Sorry about that. It's really unrelated to what Mr. Williams was talking about. I just wanted to confirm that the start time Monday would be 9 a.m. I didn't jot it down if that's...
It would be 9 a.m.
Thank you.
Unless you hear otherwise from us. Mr. Kelly.
Yes, I'm wondering whether, I will say that our intent is as I expressed yesterday morning, and that is to put as a panel of two, Dr. Polson and Tom Burke, then as another panel of two, Greg Young and Nick Bonsignor, and then as an individual, Rick Gilmore. And so perhaps it would be helpful. I know that you all broke to deliberate about the time issue yesterday a little bit, and so perhaps over the next couple of days, if we could just get a ruling from you on how much time we have for are 2 panels and then Mr. Gilmore in total, and then how much time that everybody will have for cross-examination in total, and people can just do with their time as they please. And that way it just gets resolved well ahead of when we actually come to provide testimony.
Thank you, Mr. Kelly. That's a good suggestion. All right. I think that, oh, Ms. Valera.
This is housekeeping. There were 3 exhibits that we referenced in cross-examination today that we would like to move into evidence. They are West Side Exhibit 183, West Side Exhibit 184, which is the poster, West Side Exhibit 152R, which is the excerpts of Ms. Maroka's deposition. And then I also noticed in looking at my notes that we had referenced West Side Exhibit 100 on Monday, and we had failed to move that in. So I'd like to move those 4 exhibits into evidence, please.
Thank
Robin
you.
McGinnis, DWR. We didn't see copies of any of these exhibits today, so I would like to wait until we have a chance to see them, and to see if they're...
Those are pre-submitted exhibits, I believe. Or are
That's
they?
correct. The exhibits that were submitted today,
Oh.
Exhibit 183 was emailed to all the parties on Monday evening in anticipation that it might need to be used. And Exhibit 152R is simply an excerpt of the full deposition 152, which was previously submitted as a placeholder to all the parties in the original exhibit submissions.
Mr. McGinnis, I would just note your objection.
Could you just say what the numbers are again, please, Ms. Boletta?
Sure. The exhibits from today are West Side Exhibit 183, West Side Exhibit 184, West Side Exhibit 152R, and West Side Exhibit 100.
Okay, thank you. I'll take a look.
All right. That concludes our proceedings for today. Thank you all very much.
Thank you.